Recording in progress.
Я вітаю всіх і прошу до уваги. Ми всі пережили ті чергові терористичні
I draw your attention. We have just survived the terrorist attack of the aggressor, and would like not to call them. And I'm thanking you that you have come. Our nation is alive, and we're going to act. We're in the middle of the war, and therefore I would like to announce some security measures. First of all, if we have air raids alert, please go to the hiding place. Please take your headphones. You can go there and you can listen to the broadcasting of our readings, but you have to take your headphones. The second point, those moderators and speakers, they should stay here because that will be a live streaming. If it is really intense, we're going to the shelter, all of us. Unfortunately, there are many shortages with water supply in many areas of Kiev, as well as with electricity. Here, there are some toilets here. I think there will be normal conveniences, but this war must make us stick to the discipline. We have to stick to our time limits, and I have a timekeeper here who will keep me under control here. So, dear friends, it's already the 5th year, actually the 12th year that we are in war, a full-scale war. That's more than 1,500 kilometers of front line, and that's terrible. And that's very comparable to the Second World War. Maybe it is even worse, because the damage is sometimes worse. However, the fact that we are a freedom-loving nation, when we're going to stand our ground, because we are on the side of the truth, and that's why the aggressor will be defeated, not only by our force, but all the civilized world is behind us, because the truth is behind us. And those who are of older generation, maybe you heard about Time Machine Band, headed by Andriy Makarevich. And once I was browsing internet, and I saw the discussion between Andriy Makarevich and some youths, and there was some vague discussion there. And he said, who attacked first? This one is aggressor. He just cut short this discussion. And this youth started to discuss that we need peace, And Mr. Makarevich said, let's get it straight. So you, for instance, come to my home and you took half of my home, and then you want to make friends with us, and that's how it sounds. But it won't be like this. We are going to win our powerful armed forces, and nobody had belief in that because everybody thought that they're weak, but they stood their ground during the first wave of invasion, and now they are sacrificing their lives as well as civilians, and all of the Ukrainians are under danger. But again, I will repeat, we shall stand our ground. So let's commemorate the memory of the deceased of both the military and civilians with a minute of silence.
Дякую, прошу сідати.
Thank you. Please be seated.
Ну, а тепер
So,
щодо тематики.
let's get to the topic of our conference. I express my gratitude to you. We have now 83 people here, and that's really impressive, despite the fact that we are under danger here in Kiev. But you have come here. That means that we chose the appropriate topics for our conference. And we have 166 people registered offline and more than 200 online. And our conference, it's already the 12th conference dedicated to the memory of Academician Igor Pobirchenko, and I announced it opened. What about the topic? It may seem strange if you start to discuss Ukraine as a seat of arbitration, the place where the war is going. But no, that's a reasonable and good policy. We demonstrate with our activities in the sphere of arbitration with the activities of our other institutions, like Chamber of Commerce, represented by President Chizhikov. We act as normal. We want to demonstrate the whole world that our institutions, our civil society institutions are operational, like Court of Arbitration, and the state supports it. The second point, we have some achievements, and we're going to tell about it more. We designed our conference in such a way so that they cover these issues, and we are going to have the first session to the arbitration system. And the second part will be about the state courts operations and the supervision over arbitration. We just wanted to demonstrate all the elements related to arbitration, and these elements show that Ukraine now is in the position that we can work as normal, and our powerful moderators and our speakers will prove it. And we have a special speech on that. And the third point, we want to demonstrate that we are ready to rebuild our Ukraine at the new level, at the economic, social, and political level. And we are already building the prerequisites for new investments to come. We build the foundations, and that's the message to investors, that the investments will be protected here, including via arbitration. So these are three goals, three aims for our conference. Take into account the war and security measures. We have not invited some high government officials to make addresses, but of course, their representatives express their favorable sentiment in terms of how arbitration operates, but we just chose not to select them, to invite them in person to this conference. But one institution under which we work, that's the Chamber of Commerce, and Chamber of Commerce is taking care about our work, and that's the Chamber of Commerce and Industry. We use the premises and the chamber's personnel worked on more than a month to make this conference possible, and we're very grateful to them. And Gennady Dmitrievich Chizhikov was taking a big care about our conference. That's why I'm giving the floor to him. Thank you. Dear Mykola Fedosich, dear Roman, dear friends, dear colleagues, I would like to greet you on behalf of Chamber of Commerce and Industry here. I know how much you are doing to make it possible so that the international arbitration develops in our Ukraine and is becoming a powerful institution trusted by the whole world and our businesses. And that's very important for us. The Chamber of Commerce and Industry, our respectable institution, it considers that it's a platform to serve as a model for integrity, honesty, and abidance with the law. And we, as the Chamber of Commerce and Industry, will make our best so that you will feel comfortable to do your job as lawyers, as the professionals, so that you can implement your activities at these platforms from the perspective of judges, of defense lawyers, as arbitrators. On our behalf, I would like to say that the cause initiated by Academician Pobirchenko is alive, and it is developing for more than 30 years. This institution has been operating for more than 30 years. And I, as a president of the Chamber of Commerce and Industry, and also as the head of the European Association of Chambers, I'm very delighted that when I'm communicating with my friends from the world, I'm always receiving the questions how your court of arbitration operates, and I'm very pleased with that. That's just an achievement, and that's a proof how our prestige is high in the whole world. And Mykola Fedosich recollected that we are now surviving through the difficult times, but Ukraine's force is not about our bravery only, but it's about our ability to think about the future. And I'm totally sure that Ukraine will draw the attention of the whole world. We are sort of like in vogue in the whole world, and everybody is waiting for the war to be over so that we can start to rebuild our country, and the issue of investments will be extremely important and to the point. And we are now working with the Parliament of Ukraine to create this, to strengthen this platform of ICAC, International Court of Commerce and Arbitration, to make useful. And that's one of the elements how to build the right policy for investments. And I think all those who are present here and those who are watching us online, we have a lot of friends and colleagues abroad who are ready to support us with their expertise, with their knowledge to make our institutions more powerful. And that's why we're going forward. We are continuing these activities initiated by Mr. Pobirchenko 30 years ago and developed by Mr. Sullivan. The Chamber of Commerce remains committed to support the Court of Arbitration to make it really independent and to serve as a model of an institution as a cutting-edge type of institution. I would like to also that's a great that we have so many people here that you are interested in further development of this institution to make it even more efficient, to resolve the disputes, to serve as the model for integrity and honesty. So I wish you inspiration, interesting discussions, interesting ideas to further promote the community, both here in Ukraine and around the world. I wish you success and let's go forward. Thank you. Thank you, Gennady Viktorovich, for your support, for your kind words. We will try to do our best. Dear colleagues, we were deliberating over the topics for our conference, and now we're going to listen to the report from our member of the parliament, who is one of the primary figures in the area of legislation, in the area of judiciary, including arbitration. Dear Roman, I'm really grateful for you to participate, and you even had the injury in your hand by the missile. Still, he came here. So this is the person from the Parliament of Ukraine who is one of the first initiators who started this process of dispute resolutions procedures. And I give the floor to Mr. Roman Babi, member of the Parliament, member of the Committee on Judiciary and on the European Court of Human Rights and on alternative disputes resolution. Roman Vyacheslavic, I give the floor to you. We are going to listen to you very attentively to hear and to learn about the plans of our state on this issue. Thanks, Mykola Fedosovich, for this warm introduction. I greet all the participants, and I thanking those who organized these 12 readings in the memory of Academician Pobirchenko. So you are still preserving this tradition despite these difficult times, and you always raise interesting topics, and you are gathering professionals at this platform. And I'm also thanking for this opportunity to make a presentation on the state policy on arbitration's development in Ukraine. So within my speech, I'm going to tell you about the alternative ways for disputes resolution. And so I will use this abbreviation, alternative resolution, alternative disputes resolution, ADR, and we are going to discuss arbitration as a type of ADR, because that's our key topic. And I'm supporting the idea that we are building the whole of the government policy on alternative waves of disputes resolution. But what about the government's policy, or state policy? So that's the coordinated activities of the state bodies to achieve specific goals. So the state policy, how paradoxical it may sound, it could be sort of like lack of activities in this area. And so that to avoid arbitrary interference, and that's why we have to, when we see this lack of interference, that's one of the bad marks. So what should be the state policy? Maybe this laissez-faire policy is better for arbitration institutions so that it will be fully independent and there will be no impact from the state. But in my view, the state must be active in this area. It can be more active in one area and some less active, but still, I think we should think about the inclusion and the specific role of the government institutions. Till recent, and that's my personal assessment, the state policy in this area was quite fragmentary and non-systematic. But there are some trends and which bring us to the need to adopt a better, more systematic approach, take into account the global trends, the global policies, and we have some own problems, lack of personnel, big time limits for proceedings, but we have a demand for quick and expedient disputes resolution. And but we can observe some good changes. According to my personal observation, the situation has started to change for the better when the committee hearings in the parliament were held in the parliament on alternative disputes resolutions. And I think these hearings became the starting point for dialogue's launch. And I will not go into detail on the recommendations of these hearings. They took place 1 year ago. And there were a lot of discussions during this year at many platforms on these recommendations. However, what actually happened after these recommendations were produced? The key recommendation, which was supported by the Parliament Committee, to create the interagency platform to discuss these issues of alternative ways for dispute resolution. And the decree of the Cabinet of Ministers was adopted to create such a platform. And this council was created. It is headed by the Minister of Justice. There are a lot of deputy ministers from many ministries are parts of these councils, from the parliament, from the International Court of Arbitration, from many other civil society organizations, international organizations. They are participants, they're members of this council. And I think that this council works with many issues, but I think the key objective for this council is to promote the coordination and communication of the government institutions, the judiciary institutions, and international institutions in the process of alternative resolutions of disputes. And I hope that this mechanism will be launched after it will be fully it's the human resources will fully complete it, because one of the officials was fired. So now there will be the first meeting of this council will be very soon, and I think it is very platform that will help with developing state policy in the area of ADR. And I think that understanding that the council includes a lot of members, of course, its work will be realized through many working groups. And and a European integration process also contributed to the development of ADR. And the Cabinet of Ministers adopted the roadmaps this summer. And one of these roadmaps included in the judiciary section, included the mentions on the activities on ADR with the specific timeframes to be implemented within 2025, 2026. So you can read these documents. I will not go into detail into these roadmaps. One thing, I will give you the citation. So the activities will be developed to promote and popularize arbitration, in particular in the area of investment disputes, in order to strengthen the investors' positions. And this goal must be achieved by the third or fourth quarter of 2026. One more document to be adopted is the strategy on the judiciary development. It is still in the works, but it is the final stage of its adoption. And its strategy also includes a specific section on ADR, it includes the specific goal on access to justice. So this draft of this strategy is very close to these recommendations from the parliament hearings, and some of these recommendations are already implemented, because actually the recommendations included creation of this council, and the council has been already created. There were also some recommendations on mediation, pre-court mediation, on arbitration, and there was a specific recommendations on enhancing the role of arbitration for development international arbitration from the perspective of investment disputes resolution, and enhancing the guarantees for confidentiality for arbiters. So we may see that these strategic documents are very close in key issues, and they are very close to those recommendations by the parliament hearings and the recommendations from the professional community, because these recommendations were actually developed with the support with subject matter experts from the community. And I think that's some sort of a starting point to build the government policy, the state policy. So I will go into some detail on some laws, some future draft laws, because we are going to discuss it, the role of courts in building the state policy on arbitration. So as regarding, probably you know, there is a draft law 1241 on expanding the scope of authorities of the Court of Arbitration. It's quite small, and there are two directions. The first direction is on a broader understanding of the notion of international dispute. There must be new criteria for this notion. Somehow there were some changes in this draft law, and these criteria were not included into the valid laws. And without doubt, these new criteria on international disputes will enhance the scope of those disputes which could be under the jurisdiction of the arbitration. The second is about Ukraine as a seat for arbitration. Hence, the objective for these provisions is to make our country as a seat of arbitration to resolve disputes between our country and investors and between different countries. And this draft law was adopted in the first reading. The committee provided some comments, and the committee recommended it for further adoption. So now the Parliament is going to include it into the agenda, and then we are going to have it voted in the Parliament. One more area on the International Court of Arbitration is regarding the amendments to the law on arbitration and also to the law on criminal procedural code and the code on bankruptcy. And the Ukrainian Arbitration Association developed some suggestions, and Elena will be the moderator further, and we are going to have some preliminary discussions to register a respective draft law on this issue. And everybody who's interested, you're encouraged to take part, included the members of the Supreme Court, and we want to have this law as quality as possible. The key issues in this draft law are about the maximum alignment of the notions including on arbitration tribunal with the terminology used in the courts. We are going to discuss the arbitrability of disputes, about the confidentiality of arbiters. We are going to discuss how to disaggregate the scopes of responsibilities between the courts of arbitration and courts of treaty. And one more topic, which is specifically interesting, and how the enterprises under bankruptcy could be parts of these arbitration cases. So you can see that there are different topics related to ADR could be included here. As regards mediation, we are not going to discuss now some amendments to the law on mediation specifically, but we are going to discuss some additional elements which may have an impact of a mediation. For instance, the Minister of Economy is going to devise a new draft law, and we have a new draft law on labor disputes, and mediation could be part of it. And now this draft law was recommended for the first hearing, but it has not been adopted in the first hearing. I'd like also to mention quite a big research on encouraging the state to become a mediator for the parties and the dispute resolution. It's quite an interesting research. We can discuss, you can see there the perspectives for the use of mediation or some restrictions on mediation agreements or recommendations on the use of specific meetings with mediators, and obviously on specific trainings on ADR. And there are some draft laws on procedural aspects. Some of them are still in the pipeline, some of them are still in the works, and so we discuss them with the authors of these draft laws. We have some discussions with the Ministry of Justice as well. As for European courts, we don't have a big progress here. That's the draft law 3411. It was adopted in the first hearing, but it is still postponed for the adoption back in 2022 on amendments to this draft law. But somehow, after the large-scale invasion started, it changed a lot of our plans. And our parliament hearings include a recommendation to get to work on this draft law. And the committee hearings made a recommendation to further develop this draft law. A couple more points on pre-court disputes resolution when a judge is involved. There is a shared understanding that this institution must be developed, modified, or reformed, because the current state of this institution is not that efficient. But before we're going to design a draft law, we must do some analysis of the current practices. To recapitulate, I would like to say that the Parliament of Ukraine works on these issues, but we're in the middle of the war, and that has an impact over the processes, how the Parliament works on that in cooperation with the Ministry of Justice, other institutions, and the government also has some European integration priorities, and we have to do a lot of work to be done in this area of European integration. But our committee has the first goal on a judiciary reform. And in my view, ADR institution must be one of the key elements of the judiciary reform, because citizens must always have an alternative to resolve their disputes through mediation, through negotiation, through arbitration, through other alternatives, ways for disputes resolution, in addition to the traditional courts, which can be lengthy, expensive, especially for the state. And the better we have the results from these alternative ways, the easier it is done, and the more efficient results we're going to have for the judiciary system in general. It will not be overloaded with so many cases, because some of these cases could be resolved through these alternative ways. And we have to remember that these alternative ways, it's not about the competition with courts. It's about helping courts and about providing new opportunities for citizens, for businesses to restore their violated rights. And that's the thing that the government institutions should keep in mind when they design new policies. And the last thing that I would like to mention, actually, it is the legislative changes are not sufficient to change the overall situation with ADR. As regards the perception of ADR from the citizens and this low popularity of ADR is probably rooted in the low awareness of the population on the ways how these ways work. And we have to undertake our joint efforts of the professional community, of the state, of the parliament, of the judiciary system to raise this awareness. And these efforts must be coordinated. Everybody should be aware of the ultimate goal and how we're going to achieve it, so that every participant have to understand their role. It's only the coordination can lead us to the synergy to bring ADR to the new level, that everybody is willing to get to this level. Thank you for your attention. So we parked the questions for the last part of our conference. Dear friends, I applauded to the presentation of Roman. You know why? Because he provided us with the exhaustive information what we're going to expect from the state for the next years. The second thing is that there are no revolutionary ways to change something, because I think a revolution is something awful, because it must be about the systemic changes, and now it is the best way to go step by step, and that's our position, and that's our experience of international commercial arbitration court, and we are the only institution in Ukraine which didn't go revolutionary transformation, meaning like everything is broken down and we are going through this good way of development, like step-by-step way. And you can ask questions afterwards. I'm really grateful to you, Roman. And despite the fact that Zoya, that head of our committee, so we are sticking to our time limits. So I am thanking to you, and thanking to you, Gennady Dmitrievich, and thank you for your information on the information from the state. Now we're starting the first session. I would like to underscore that the moderators, we have brilliant moderators for both the first and second session. They are personalities, and I would like to present Elena Sergeyevna. You know her. She recently defended her thesis to get her PhD in law. Let's greet her on that. And I think it's even better than a doctor of philosophy. Still, I think that's the very prominent degree. So, Elena, I'm giving you the rules as the master of ceremonies. Thank you. Yes, actually, I would like to extend these compliments to everybody here and those who organized this conference. Despite all the obstacles and the difficult situation that we're having, now we're going to discuss very important topics today, which are still very actual now, despite the war, and we are becoming stronger. And now we have a new perspective over new opportunities. Maybe under the peacetime, we would not have seen them. Now we're going to talk about made in Ukraine arbitration jurisdictions of new generation. So we're going to speak about Ukraine as a seat for arbitration. We're having 3 speakers with us. One of the speakers is online. That's Professor Catherine Rogers. She is professor of she's scientific fellow from University of California, a former professor of University of Maria from London, and She is also representing ICDS and from Oxford University Press and reporter of American Institute of Law on the reinstating. So she will be with us online, and we have two speakers here offline. Oksana Karol, she is a defense lawyer and she's expert in international arbitration with 15 years of experience. And she was a lawyer in many cases in the arbitration under the ICC rules, Stockholm Court of Arbitration, and she specialized in international arbitration in the sphere of energy, construction business, and she were going to applaud to everybody. And she was part of Hogan Lowell firm in Warsaw, and she was part of many cases, in many cases. And our third speaker is Alexander Druk. He's the head. He's one of the lawyers at Sayenko-Kharenko legal firm, and he was represented the interests of many clients in the areas of banking, securities, mergers and acquisitions, shareholders disputes, aviation, construction, energy, sports, many other spheres. And also, Alexander is also advising on activities to ensure arbitration in the territory of Ukraine. And our speakers are recognized by many international ratings. And we are going to speak about the Ukrainian situation, but we're starting from the broader topic about the seat of arbitration, about the criteria. I would like to give floor to Professor Rogers. Hope that you will be able to see her on screen. Okay. Professor, the floor is yours.
Hello, thank you for having me. I'm delighted to be here virtually, and I hope one day I will also be able to visit you in person. That wish is in many ways a good introduction to our topic today, which is about place, which is a synonym that is often used to designate the seat of arbitration. It's sometimes called the place of arbitration. In fact, that's place is the word that the New York Convention uses, but we will be talking virtually about it today and talking about how the seat can be both a physical place and a virtual place in more modern times. I'm delighted to be here because I support Ukraine through all of the tragedies, crisis that you're going through now. It's on my mind every day. But I also do believe that international arbitration and the Ukrainian friends and students that I have through our international arbitration will also be part of the rebuilding of your great nation. So I'm really delighted to be in a very small way part of that today. So my task is to give you a more general, I guess, international and also academic introduction to the concept of the legal seat, which does not exist in domestic arbitration as a concept, but is really essential in international arbitration. So as I'm an academic, let's start with a definition. So the legal seat is sometimes called the juridical home of the arbitration. The word seat has a very physical connotation. It's where you sit. It's literally a where. But in fact, it is, you might think of it much more as a legal anchor in international arbitration, because the seat, or in the language of the New York Convention, the place where the arbitral award is made, is the jurisdiction that has the legal anchor to the arbitration. And we'll talk a little bit more about what that means, a legal anchor. It derives from the consequences of choosing a seat. So the seat and the law of the seat, particularly the arbitration law of the seat, provide the procedural arbitral framework for the for international arbitrations. So, for example, it might provide whether you can have interim relief. It might provide for procedures when, in very, very narrow situations, courts might assist in the arbitral proceedings. But most importantly, the seat is the place where the courts have the exclusive power to set aside or annul an arbitral award. Set aside and annulment in the seat are different from recognition and enforcement, which is what happens usually where the losing party has assets. The set aside or annulment is determined, the standards for set aside or annulment are determined by the arbitral law of the seat. The seat is also sometimes described as determining the nationality of the award. It is where the award is made for the purposes of the New York Convention. And made sounds like a very simple term, but it actually is a term of art. It's a technical term of art in the New York Convention. And it can have a couple of important consequences. An award has to be made in a jurisdiction that is a signatory to the New York Convention for reciprocity to be applicable by other courts when the award is seeking to be enforced in a foreign jurisdiction. Where the award is made can also have implications for other aspects of the application of particular laws, which are more technical than we need to be. But you can see from this that the seat, even though we designate a place and it seems like the physical place things will happen, in fact, much more importantly, it has a number of legal consequences. It is also, it can be, and increasingly is being seen as the place or the jurisdiction whose law will govern the arbitration agreement. So not the underlying substantive contract. So contract for construction, you might choose whatever law to govern the construction aspects of the contract. But with regard to the arbitration agreement, how is it interpreted? How do we know what the scope is under the arbitration agreement? That law that you use to interpret the arbitration agreement may be, and increasingly often is, the law of the seat. So there are several legal consequences for choosing the seat. It is also, as a default, where the arbitration is presumed to take place. But as we'll see in the modern era, that's not necessarily the case. As in case you haven't already intuited, I think this quote from Gary Bourne captures the importance of the seat really well. Selecting the seat is one of the most important decisions in structuring an arbitration agreement. And I couldn't say it more clearly than that. Selecting the seat, given the implications, is incredibly important. Historically, it was even more physically significant. It was presumed that every aspect of the arbitration happened in the seat. So there was a link between the seat. It was not only the juridical home, but it was the physical home of the arbitration. So much so, and for younger people, this might be hard to believe, it was not only assumed that all of the hearings would take place in the seat, but actually at the end of the arbitration, even if they had by conference call, before there was video calls, conference call deliberations, and they decided on the substance of the award, and they faxed, for those of you who know what fax machines are, faxed the award back and forth and finalized it, they literally would still, all three arbitrators, have to fly to the seat and physically sign the arbitral award in the seat. That's how important, historically, the seat was supposed to be. And the idea was this award was made in the seat. And back then it was a very literal making. So the signing had to be in the seat for the award to be made in the seat. And it also was true, much more universally than it is today, that an award that was annulled by the courts in the seat was completely null everywhere. And in fact, under the New York Convention, one ground for refusing to recognize and enforce an award is that it was annulled in the seat. If it was annulled in the seat, the idea is the award was dead. It was like putting a stake, a wooden stake, through the heart of the vampire. It was really, really dead. But today, also this idea that an annulled award is dead has been called somewhat into question. In France, awards are routinely reviewed regardless of whether they were annulled, and many jurisdictions will consider enforcing an award even though it has been annulled. Today, we have the seat being important for the legal implications we've already reviewed, but not necessarily connoting physical consequences. That's really important, especially for a jurisdiction like Ukraine, where you have a number of physical challenges right now. But it's also really interesting to see, as a consequence, I think, of the importance of the seat, that we see states competing to attract international arbitration. They compete to make themselves a strong legal seat so that parties will put their jurisdiction into their contracts as the selected legal seat. So why would they do that? Before I get to how they do it, let me tell you why. Part of the reason is because it can have financial benefits. They call it international arbitration tourism, because when an international arbitration takes place, lawyers come, arbitrators come, the local law firms are oftentimes employed, local conference centers and hotels are employed, local translators are employed, and it is a source of essentially tourists, a specialized type of tourist revenue. In addition, it has really implications for the state as a good venue for investors to put their foreign investment. Why? It's a signal to the world. This jurisdiction, Ukraine, is open for global business. We understand what foreign investors need in reliable dispute resolution, and we have made sure our legal system provides it. And that can even lower, for example, a good legal seat and a good arbitration clause can actually lower the political risk insurance for a contract. So it can have actual value for parties who choose a good seat in a good arbitration regime. So how do you become a good seat? Number one, the number one implication of the seat is that your arbitration law applies to govern the arbitration. So very important to have a good, effective arbitration. But even more than the written law on the books, it's really important to have a reliable court and legal system that promotes the rule of law and sustains the rule of law, especially with regard to arbitration matters. That means judges and lawyers who are knowledgeable about and respectful of the limits of international arbitration and its interaction with the courts, that it needs to be, in a sense, both internally resilient and effective, but also insulated from the legal system more generally. It is meant to operate autonomously from the legal system, but with support for the legal system. You also, in order to be a good legal seat, need to have what I will call reliable arbitral infrastructure for our arbitration tourism. So that means having hearing rooms. International arbitrations, especially very large ones, oftentimes involve a lot of technology, meaning screens and microphones and translators for the team. I will say this program and others I've attended virtually in Ukraine and Kiev have already demonstrated to me that you have terrific technological support and a real sense of planning and foresight in setting up everything, testing, which is not even the case in many other well-known seats. So compliments to you on previewing that to me already. You also need local lawyers, which is part of why I assume they have this conference and many other programs sponsored by the Ukrainian Arbitration Association. You are busy training young lawyers and lawyers who are new to international arbitration on how to navigate and be effective in this context. You need translators. I've already heard a translation in this program from the introductory remarks, and clearly you have also that in this strong, you've got that set up. Also, to be honest, I had not used Zoom previously with translation, and I'm happy to say it works well, and I'm impressed again that you were able to set it up so seamlessly. So let me just provide a few conclusions before you move to your Ukrainian presenters and who can give a more sort of internal viewpoint. I think one of the takeaways I would say is that Ukraine really is going to be a beneficiary, already is a beneficiary, of the modern view of the arbitral seat as the juridical home of an arbitration. That means it can have arbitrations physically in the seat, but especially as the conflict continues and sometimes travel is uncertain, it can also have hearings outside of Ukraine, but keep Ukraine as technically the legal seat of the arbitration. And that balance, I think, is especially valuable for Ukraine given the modern situation, the current situation, which again, we all hope will be better soon. In addition, I think that in the long term, as Ukraine rebuilds, and I think international arbitration will both help it rebuild and benefit from its rebuilding, but investment in the rule of law, and most importantly, not laws written in the books, but really the human capital, the lawyers, the judges, the translators, the support staff, who all support the rule of law, are really keys to long-term success. So with that, I'll stop my sharing and congratulate you already on what seems to be an excellent program and wish you the best for the remainder of the program.
Я не знаю, чи перекладають зараз, але ми
I don't
дякую
know
дуже
whether
за
there is translation, but thank you very much for your report, for the things you said, and that it will be the grounds for our further discussion in Ukrainian dimension. And we've already heard some compliments about Ukraine. Thank you very much, Mr. Roman, for your speech regarding the state policy and the future plans in this sense. For the international arbitration, it is also very important for our discussion. But with this, let's start with historical experts in order for us to understand where are we and to understand, in order to understand where are we going, we need to understand where are we now. So let's start with the way we had institutionally and legally. And my first question to Oksana, what institutional development have we had in Ukraine, and what is a legal base we have developed so far? Thank you, Elena. Greetings, everyone. Thank you very much for coming today to this venue. When I was preparing for this meeting, I thought that actually in the last 25 years, during the first quarter of the 21st century, I can say that Ukraine had a very tough way. And I'm very glad that I was able to be practitioner half of this way and have seen how it worked. And we had a very tough way all around. First of all, institutionally, because without legal base, without institutions, I guess it would have been really difficult to imagine arbitration in Ukraine. And in the last 25 years, we have the institution, arbitration as institution, not only on Ukrainian level, but also on the regional level. It is a recognized institution, recognized by, I can say, around the world, maybe not all around the world, but in Central and Eastern Europe. Not only UMAC was established, but also Marine Arbitration Commission, and we can say that it is a significant development in the last 25 years. As for the legal base, I can say that probably the most significant milestone for me, and I guess for all of us, that is the legal reform, which started in 2017, because we had adaptation of very big adaptation, but it is not revolutionary, as Mr. Solomon said, quite gradual adaptation of Ukrainian legislation to the international UNCITRAL, and we had the changes in our procedural codes, which have helped arbitration to develop, to support arbitration. I'm not going to name all the amends, but the changes were really significant. One of the tools which I can name, which was very important for me, that was the support of the international arbitration. So the changes are indeed significant. And if we consider New York Convention, it started, it's in force now. And I remember in the beginning of my career, when we met the colleagues in the court on the recognition of the arbitration decisions, and we faced a challenge because the national judge did not know what is European convention, that there are the international agreements and how it works and what is the language of it. And so far, we do not have anything similar, and that is indeed big. And if we take historically, it seems like 25 years. 25 years, of course, it's a lot, but nevertheless, it's also quite a short period of time for the changes which have happened here, considering all the crises which happened in our country and the establishment of the country as an independent state. So lots of things have happened, and we had institutional development of UMAC and Marine Arbitration Commission, and also the legislation on the national level. Thank you, Oksana. And the question to Alexei. Arbitration in Ukraine now. What is it now? Thank you very much. I'm also very glad to participate this venue, and I'm very glad to see all of you in person, because we haven't had such a broad audience regarding arbitration. Speaking of the arbitration in Ukraine, and what is the seat of the Ukraine in arbitration? Well, I can say that we already see success, because we can see the statistics published and the number of the cases considered every year, and it is significant. If we compare it to the institutions in Eastern and Central Europe and in general, we can say that indeed significant results. But beside that, I would like to say that Ukraine is the country for arbitration, not only for UMAC, but also recently we had the arbitration on the regiments from the foreign institutions with a seat in Ukraine, and we had lots of cases where the reglement ad hoc was, and we had quite a lot of them. And I remember that 10 years ago, we had a case, investment case, regarding regiment of Incentral against Kazakhstan, as far as I remember. So we have the practice when the parties from different parts of the world choose Ukraine as the seat. It's thank you, Alexander. I completely agree with these observations, and what is also interesting in this case is that during the war, even despite the war, the tendency you have just mentioned, that Ukraine as the place of arbitration is not limited by two regiments, but the other regiments are applied as well, and therefore we can say that the parties are not afraid to choose Ukraine as a place as a seat for arbitration, and therefore institutions are not afraid to register the cases with the proceedings which are seated in Ukraine. But of course, in order to have the understanding and to have the arbitration seat, of course, in this case, we cannot underestimate the international ICAC. And they did a lot in order for Ukraine to be considered a safe place for all these thousands of cases which were considered by Ukraine in recent years. But let's discuss another aspect which was mentioned by Professor Rogers, and which is also very important for the parties, and that is the understanding whether it is a safe or not safe seat. And I do understand that we will have a separate session on that, but as a criteria of selection of arbitration, we would like to talk about the courts and the court practice. Oksana, what is the situation so far in arbitration? Well, I have a task to give a historical excursus. What do we see nowadays and what we didn't have even 10, 15 years ago? So considering the period when I started my practice, what do we see now? In our court practice, we can see the consistent confirmation of the arbitration agreement. So we do understand that this is agreement the part of the main contract. Then we can see that there is extraordinary positive thing for business, for the community, that is consistent, moving away from the formalism when considering the cases on the implementation of the decisions of the arbitration courts. And all in all, we can say that we have the process of deformalization of the implementation. And quite a lot of you know that 10, 15 years ago, when we had a question whether we have mentioned correctly these or the other arbitration institutions, we had the translation issues, and finally we have overcome these problems due to legislation amendments and also the change of the practices. What else do we see? The limitation of the cases of the limitation of the interaction of the judges with the cases and interventions. And as Professor said today, one of the reasons is a human capital, and that happened also due to our legal community. First of all, of course, due to the work of the judges. And personally, I was very glad to see that there were the changes in our Supreme Court, and they were the people who speak different languages, who know what is arbitration, and who has worked with it, and who can use their skills in order to develop the new practices. And all in all, we have very good results, and I hope that these changes will continue. And we will have less cases of intervention in arbitration cases, and also the international support for arbitration. For example, there are the support like safeguarding. 10 years ago, nobody was talking about it even, but nowadays we have quite a good practice, well-working practice. And of course, lots of things could have been improved and many challenges could have been resolved, but we are still moving forward, and that's good. Incredible work of the judges. So the judges played a big role in the development of the court practice, and as a result, we have pro-arbitration practice and the position of the Ukrainian judges regarding the international arbitration. Thank you, Oksana. Alexandra, do you have anything to add? Yes. So speaking of the courts, I can briefly tell you something, because we've heard from the first speaker, Professor Rogers, that there are some very important elements, and stability of the sustainability of the process is important. And I can say that the indicators we have, for example, regarding the speed of the consideration of the cases, on the sustainability of the practice, and also even regarding the price of the consideration, they are competitive. with the leading centers for arbitration around the world. For example, I have conducted a small comparison on 2025, on the results in 2025, how many applications were filed, 24, and none of them was satisfied. So now the success level is actually 0 so far. And as for the period of consideration, the average one is 190 days, which is around 6.5 months, which is quite fast. For example, the Switzerland, they have the 160 days, but you have to take in account that the Switzerland is they have only the Federal Supreme Court, and they have only one line and one instance. In Ukraine, we have two instances, Appeal Court and Supreme Court. And if we consider these results, then we can say that indeed they are very positive. And if we consider, for example, even the price in Ukraine, of course, that is the nominal level, that is a half of the living minimum. But if we compare to the other jurisdiction, that is high. In Austria, it is 5% of the arbitration decision amount. And if we consider, for example, the Switzerland, in this case especially if the complaint is applied by the non-resident of the Switzerland, the price can be up to 200,000 Swiss francs. And recently we had a case where the person who applied the complaint had to pay 160,000 crowns. And sometimes it stopped the people from applying unjustified claims. But in some cases, the parties, they just want to protect their rights, and they can see that there was some kind of violation during arbitration, or there was no arbitration agreement, and indeed they want to protect their rights. And of course, in this case, in Ukraine, it is easier to do than it works in the other countries. Thank you, Alexander. And I can add that even despite the fact that statistics in Ukraine on the cancellation, which is carefully collected and published by MKAS, and even though arbitrations still that is 99% of the cases which are conducted in Ukraine. Nevertheless, I can say that, in fact, we can be competing with Switzerland because when it comes to statistics, because if we consider the statistics on the website, on average, less than 1% of the decisions made on the territory of Ukraine as arbitration seat are cancelled by the courts, even though the access is to judges is easier and cheaper here. And when I'm abroad and I'm telling about our court statistics, they are so surprised because the number of cancellations here is quite small, and it is almost impossible to cancel the decision made in Ukraine, and the implementation statistics is also quite high, and it has improved quite well. And we have conducted a big research, which we have published before the full-scale war and during 1 year of since the establishment of the court register. And now we have the war period statistics, but they are not published yet. But the statistics of the successful implementation is more than 85 and sometimes even more than 90%. That is a very high percentage. And we have to understand that the conditions for the cancellation, that is not always an issue with judges, but it's also sometimes the matter of the decision. So statistics is quite good, and we have to be proud of it, and we have to be telling that to the foreign colleagues, because some of the myths regarding Ukraine and Ukrainian legal system, they exist. And the positive thing which we have in the arbitration is something that we have to be sharing. But let's move to another topic, and historical development of investment arbitration. Oksana, what kind of successes do we have here? Well, when we are talking about investment arbitration, I can say that we have not that many successes, but more of lack of successes, because of course we do not want to see Ukraine as one of the top defendants, because we as community, as people, we have not quite a good statistics, and it means that not everything used to be good in Ukraine with investments. But nevertheless, I still see positive things in negative things. In 25 years, Ukraine was one of the defendants, and the foreign investors, they were contacting in arbitration not once. First, what does it mean? That first of all, that the Minister of Justice has a huge practice, huge experience, and we can say that we have lots of specialists who understand what is investment arbitration, how does it work, how does the public and private international law works, and what are the procedures. And this understanding gives, and I hope will give, us the opportunity to avoid this kind of dispute on the level of the state. And we, as arbitration community, which used to have, which had the access to these cases as experts or as the party, as the representative of the party, we have experience now, and we know how to work with international colleagues, the recognition, visibility on the international market of arbitration. And I can say that, considering my latest experience, working experience in Hogan Logos, we have very good reputation of some arbitration colleagues, and we have the colleagues who have a good investment arbitration. I hope they are temporary abroad, and I hope they will return soon to Ukraine. That is speaking of Ukraine, but as a state. But in 25 years, we have seen that Ukrainian business also used this mechanism, and we have also a few applications, and we can see the ones which were made by Ukrainian business abroad, and it means that the tool is the business knows about this tool, business knows how to use this tool, and this tool works. And of course, then there is a question of the future due to your integrational process, but then that is a question of the future. Alexandra, do you have anything to add regarding the situation? Well, I can say that indeed, this draft law, which we've heard about in the beginning, is supporting us. It helps us and investors to be sending disputes to Ukraine, to sit in Ukraine. And here we have, I can say, some potential for that, especially when the dispute amount is not very high, because each investor assesses all the factors which can have an impact on the seat of arbitration. And what we have already discussed today regarding efficiency of the legal system, court system, and the price of the proceeding, well, that are the positive factors which investor can take into account. We didn't mention the price of legal services because the seat is selected, then the main thing is the potential work in the courts. And if we, for example, select London, Paris, New York, Stockholm, in this case, major expenditures are on lawyers. And in Ukraine, of course, the services, they are much more, so to say, affordable. And the investor which will select Ukraine as a seat, this investor can be sure that in Ukraine we have professional local advisors which will be able to support this case in the court. And if investor consider that there were some kind of violations, to confirm that these violations have to lead to the cancellation of this decision, or on the other, or otherwise to protect this decision in order for it to be implemented. Let me add a bit, a very important remark. Investment arbitration is probably one of the most affordable tools in countering Russian aggression. I mean, Crimean cases. And we can see that since 2014, Ukrainian business has made the request to Ukrainian investment arbitration to protect their rights, and now we have the proceedings ongoing for the Russian Federation to reimburse the funds, and that is a tool which helps Ukrainian business to have the right for fair justice. And I can add for myself that Ukraine has ratified very big number of bilateral investment agreements, and indeed it is impressive if you consider even the average amount. And of course, our Euro integrational way can adopt the agreements which were conducted with the European Union. But nevertheless, it takes some time as well. And maybe that is not the worst problem we might have in the future. But what Ukraine could have benefited from, we could have become the seat of arbitration not only for the dispute between investors, but also as a neutral seat. And in order for it to happen, we have a fantastic legal practice. We have the law on the international arbitration. We have some amends, and some of the amends were initiated, and let's hope that in the near future they will be adopted. And of course, we have to understand, we need the understanding of our colleagues abroad that Ukraine can be a safe seat for arbitration. And I think that all arbitration community in Ukraine is interested in it. But let's move forward. And Alexander has covered the issue of the improvement of the legislation in Ukraine, and we would like to ask more questions regarding this. So what does Ukraine do in order for it to happen? Thank you very much for this question. And in fact, I'd like to, before saying that, what kind of initiatives do we have, and which were also mentioned before in the forward. And maybe I would like even to give a compliment to the court practice, court system, because court practice is sometimes is beyond the legal system, because sometimes some things are not formalized yet, but this arbitration position is already implemented, even though the legislation is not in place. And today in the forward, we were speaking about the initiatives on the comparison of bankruptcy and arbitration. And the legal practice gave already the answer to these, and this is the positive answer for arbitration. Let me refer to the case 29 as of the 23rd February 2023, very interesting case. In this case, the defendant has applied regarding one of the parties, the party which bankrupted, and one of the parties stated that in the guarantee agreement there is the ICC Hong Kong seat arbitration stated there, and the party requested from the court, in fact, not to consider this case. And at the same time, he has applied to arbitration court. The first instance has adopted it, and the consideration was stopped, because indeed there was application from the party and there were no reasons to refuse. And then the appeal court has cancelled this decision and has pointed out that at the moment in the legislation, the bankruptcy arbitration is not considered, and therefore we have to follow the principle on the bankruptcy, and it said that all of the debts are considered in the framework of bankruptcy. And then the Supreme Court comes, and the Supreme Court actually let me cite. First of all, the Supreme Court has referred to the court reform of 2012, and they said that there were the amendments in order to support the alternative resolution of the disputes, in order to recognize arbitration decision. Then they quoted New York Convention that when appealing to the court, and if the parties agree, the court has to suspend this kind of proceeding if they will recognize that unless they recognize the arbitration agreement is not valid. And considering the fact that New York Convention has prevails over Ukrainian legislation, then the courts have to take in account these, and also we have to support arbitration. And as a result, considering the fact that there is no clear regulation between arbitration and bankruptcy, doesn't mean that the code on bankruptcy should be prevailing. And in fact, we have the New York Convention is prevailing, and therefore the appeal court's decision was cancelled, and the first court instance is valid, and in this way the proceeding was suspended, and therefore the case was considered in arbitration court. And the interesting continuation of this case, because the defendant was a Ukrainian bank which appealed, and against whom there was ICC decision, and then they started liquidation. And then when the party came back to Ukraine, Prominvestbank tried to say that you shouldn't recognize this arbitration decision because liquidation of the bank has started, and the liquidation and when liquidation happens, it is considered in centralized way, and recognition of arbitration decision will be against it. And therefore, this case is already in the court. So far, Appeal Court of Kyiv has satisfied this decision. They recognized the arbitration decision. They say that there are no contradictions. At the moment, the proceeding is in the Supreme Court, and we are following it. So I have shown you the example how the court system is resolving some certain issues which are just in the drafts of the legislation documents, and arbitration community is resolving this issue. That is one of the questions which is now has to be considered regarding the bankruptcy and arbitration. But the draft law developed by the arbitration community also resolved the issue regarding the full implementation of the typical legislation, which has not happened during the court reform in 2016-2017, and namely there is a new institution of recognition of the support of the appeals issued by the arbitration. And other things, I'm not going too deep into details because in the foreword it was already mentioned.
Thank you, Alexander. And I would like to discuss some of the aspects mentioned by Professor Rogers on the seat of arbitration on human capital, as she called it. So what is happening with the community development of arbitration community development? Well, we have a huge progress here. First of all, we now some new judges being elected, and I think new judges are absolutely sine qua non, and I really encourage new people coming into judiciary system who knows the international law, who have the command of foreign languages, and they have very good knowledge of how our international colleagues work. So that's our achievement within the 25 years. But it's not about only judges. We have a strong arbitration community, including via creation of the Ukrainian Arbitration Association, its development. What I mean by this development of the community, we have a very large number of professionals who can represent parties not only in the Ukrainian International Arbitration Court, but also abroad. They have a very good command of foreign languages, and so I'm proud of it. So before the large-scale invasion had started, I had some doubts as for that we Ukrainians not so smart. No, we are smart. We are good. We are at the level of many of our foreign colleagues, of course, where we cannot be totally equal with native speakers English, but with those, for instance, who has English as a second language, and I can judge it with certainty when I work with many lawyers from many countries. And so I think we're quite equal and sometimes even surpass the level of many other professionals, take into account the conditions that we're having. And so that's impressive. We have our achievements. We have something to be proud of. But I think we need more marketing. We need more promotion to show what we achieved. Because maybe we have some sort of a negative picture about perfectionism, that we're not that good in this, we're not good in that, but we can really suggest some good products at high level. We can suggest our arbitration services, both is Ukraine as a seat of arbitration, but we can also focus not only the seat, but let's take Elena, and she can work in many other jurisdictions, not only Ukraine, in other countries where other countries has these seats. But we have to talk about that more. We have to advocate for these good practices more, not only about the statistics on our cases, but about our professionals who are behind these figures, who have their figures. They don't know just languages, but they have the techniques to work in courts, despite the war, despite all these the difficulties. So I'm not going to go into much detail about our lawyers being acclaimed by international ratings, but it's a pity we didn't do much about that earlier, but we have to speak about us more. We should set aside false modesty, and we have to present our achievements and to present our achievements to our colleagues from abroad. Alexander, do you have anything to add? I'd like to add that my practical observations say that Ukrainian legal firms become key advisors. And even if it is international law, and if you can get an expert from abroad, but you can get an expert here from Ukraine on international law, and you can represent the interest of the clients by unifying, by joining these efforts, and then the experience is built upon in this way. And Ukrainian legal firms operate in this manner more and more. Earlier, Ukrainian legal firms were sort of like carriers of domestic knowledge on Ukrainian legislation. And it was the practice when Ukrainian legal firms didn't tackle with litigation strategies. But now the situation has changed. And I agree with Oksana that the professional level of Ukrainian lawyers is it's just equal with the colleagues from abroad. I have a question to both of you. What about arbiters? Arbiters were previously just practical lawyers. So arbiters is sort of like ultimate level of professionalism. So arbiters are those who work here in Ukraine. They are super professionals who must be recommended. You have to know our own arbiters, and you have to sell yourself. Well, I don't like the word, but still, probably you have to know how to sell yourself, for instance, in Central and Eastern Europe and even beyond, to promote yourself for business communities, for legal communities abroad, we have something to present at the international market. I don't know where our gaps are in terms of not to be represented in international communities. Elena, I will just say a lot of good words about you, but Elena is our arbiter at ICC for many years, and I think we have to work more on this. And of course, there are a lot of other priorities, and it's hard, but we shouldn't forget about it. We have to move forward, and we have to sell ourselves and our arbiters. When I worked at the international firms, and I always try to suggest my Ukrainian colleagues for some international disputes. Just let's update our CVs and send them to our colleagues, and then in this way we're going to break myths. Well, today I had an impression that some international colleagues thought that we don't have a proper IT infrastructure here, but if you can imagine how we woke up today, then you could imagine how good we are at this. Because I have an experience from Germany when they send the documents by fax, and I was a bit, shocked. And so about the consequences, like the speed of document flow, and that's in Germany. So let's speak about our marketing for our arbiters. Alexander, I would like to add some practical observations. I see more and more that the parties are more and more certain that they could find an arbiter in Ukraine and assign these arbiters to specific cases, and that's what I see in practice. And I would like to add that we have courts statistics which prove that Ukrainian arbiters perform quite well at the arbitration court, and that's just pure fact. And I'm doing now a small research on Eastern Europe, and I have a graph on arbiters, including on Ukraine. And even taking these pure figures, I would say that Ukrainian arbiters are more and more assigned to the cases. I don't have the actual surnames of these people, but I can see just the numbers are rising, and even in those cases which are not related to Ukraine. So we can observe the trend here. And we have not so much time. Let's talk a bit about the current trends and sum up a bit our discussion. I would like to mention three trends. The first trend about it's about Ukraine, not actually about Ukraine, it's about regionalization, as I put it, meaning that there are arbitration clusters being formed, and Ukraine is one of the most mature jurisdictions in the area, in the region. We now compete with arbitration hubs in Paris, London, Stockholm, Geneva, and I think it's a big achievement. But it's also a big challenge because you have to be worthy of this achievement. The second is about standards. That's about response to how the trust should be sustained. And the third, about digital solutions in arbitration, so-called green arbitration. It's not about online hearings, but also using specific online platforms or digital platforms about working with witnesses, getting evidence online using various types of software. And in this way, to not to use too many papers, just to better climate preservation or planet preservation. And also we have to talk about European integration. European integration is the first on the list of priorities. And obviously we have to talk more about the investment arbitration in future. And we have to discuss the change of the regime of the arbitration system in future. I received the mention from the organizers that Professor Rogers would like to say something. Please switch her in.
I was just really enjoying the comments and wanted
Me-
add a small reflection. One that I agree, you have really terrific examples of Ukrainian lawyers who are increasingly also arbitrating in international cases. And I am sympathetic to what I understand to be a sort of mixed feeling about the need to self-promote and the kind of icky feeling you get when you talk about self-promotion. But one thing that Ukraine has that can be very useful, I think is already being very useful, is organizations like the Ukrainian Arbitration Association. There's a lot to be done online with LinkedIn, for example, and making programs like this visible to the outside world, even if they don't attend, showing them that you have these programs and that these dynamic, self-reflective discussions are happening in Ukraine can be a good signal to the outside world that you are constantly not only building and growing, but wanting to project that, making sure people know it. And then I also wanted to say reputations are built slowly over time. So even if you today have wonderful lawyers and brilliant arbitrators, it does take time to build the reputation. And it's a process that requires kind of constant care and feeding. And I just wanted to add that in so that as a positive note to say, I think that I see that process happening when I watch what's happening in Ukraine, and I think there's hopefully more room to do it. And at the risk of being a little controversial, I do think Ukraine will oftentimes, for better or for worse, be compared with Russia. And I think the comparison in many ways does a lot for Ukraine. Because right now what Russia is doing is becoming incredibly anti-arbitration. Their courts are in very biased and obviously political ways striking down even arbitral awards that have nothing to do with the conflict. And that, I think, demonstrates the opposite of what we started talking about, which is Russia is not going to be open for business even after the conflict ends. There will be a lot of investment that otherwise might go to Russia. That I think, as you continue to build your reputation for being a great jurisdiction for the rule of law and for international arbitration, Ukraine should be able to, not only for political reasons, but also just purely economic and strategic reasons, be able to attract those investments that might otherwise find their way to Russia. So I didn't want to interrupt the flow of the conversation, but hoped to just add an outside perspective to what was being said.
Thank you, Professor Rogers. And I have a question to Alexander, because he has to wrap up this session, about the window of opportunities for Ukraine. I'd like to wrap up this session. So what is the window of opportunities for Ukraine now, despite the war? I think the perspectives and their volume for future work is very significant. I would like to mention one figure. World Bank stated on the need on recovery. That's $500 billion. So if we have such a need in recovery, that means there will be projects on huge sums. There will be contracts on these huge sums. And if there are such contracts, there will be disputes. Therefore, I think there are many industries which may consider them to be very topical, like, for instance, defense industry. It's extremely topical now. It's even now there are many foreign investors who either invest or create joint ventures or buy shares in the Ukrainian industries or plan manufacturing on Ukrainian soil. There may be some disputes when you do your business jointly. There may be disputes between shareholders or about due diligence, whatever. So there is a huge prospect in terms of infrastructure, rebuilding infrastructure. There can be a lot of disputes here as well, because if you take any construction project, there may be a lot of problems around, and any party would like to have their own solution. And we could see in the International Arbitration Court, if there are big contracts on construction, they were already considered by ICAC, International Court of Arbitration. And if more contracts are signed by the Ukrainian government on construction, infrastructure, about localization of FIDIC conditions, therefore there will be more contracts like that. And I think all of the parties are well aware of the fact that if there will be more space for arbitration, there will be natural inclination for businesses to use arbitration to resolve disputes. So you can ask more questions in the coffee break. I would like to thank our speakers for their presentations. Thank you very much. Are we ready to go? No, you can't. Using this opportunity, I would like to thank you for this fruitful discussion. And due to the fact that we have a representative from the parliament here, we need to develop the market of our own Ukrainian arbitration services. I've been speaking about that for 5 years already. And these young people are crying about that, and that's great. Dear professor, you were quite amazed with our digitalization, but we're quite far advanced in terms of digitalization, and we have our cases in digital format, and we use all types of digital formats since 2022. Now we are devising a new digital platform, much more efficient, although the current one is quite simple and it is quite convenient. So I'm really grateful for your contributions, and you are going to work with your colleagues from ports. Please don't go. So we're going to coffee break till 3:15. Please don't be late. Thank you for your participation, and there are a lot of you, and that's great.
Я вже казав про те, що враховуючи важливість політики державних
I was
судів,
already saying that importance of the arbitration, well, in my opinion, that is the most important thing for the development of arbitration, because negative policy can destroy any kind of efficient arbitration, and there will be no efficiency in it. But nevertheless,
останні 5 років говорю,
I'm saying the same thing for the 5 years. Our court system regarding arbitration, and all in all, it is very strong and pro-arbitrational. And therefore, it is such a pleasure for me that Mr. Konstantin, the judge of the big chamber of the Supreme Court, I can say that we started cooperation with him long before he became the judge of the higher court, and he is motivating this part, and that is a person who is very famous not because of his perpetration positions, but also that is a person which is very wise and very smart regarding the challenges we are facing, very adequate. And in my opinion, that is one of the main your advantages. And his his judgment is important. So I will introduce a moderator. We made a special session in order to show the positive role of the judges in the development of the arbitration in Ukraine. And what Miss Professor said, that is something we have to explain to the international community, because from the perspective of the state judges, and what is most important, they are making the decision on the recognition of the decisions of the arbitration. So with this, I'm passing the floor to you. And today, as never before, we have to be sharp on time, and I hope that these our audience will also do the same. Thank you very much. Mr. Konstantin, the floor is yours. Well, first of all, I think that you have to lose this hope. Thank you, Mr. Valentin. While I'm just processing this compliment, and I'm so proud because I'm considered to be so adequate. Let me tell to my colleagues on how we are going to organize this session. So since the very beginning, I have to inform you that probably it will take some time, put something soft there, because 1 hour 15, 1 hour 20 minutes for these guests, just look who we have today here, is not enough. And beside that, we have presentations from them. Well, you know, it's the International Commercial Arbitration Court. I think that it's not a secret anymore. Was very positive regarding the implementation and disputing of the decisions to be conducted by the general courts, not the economical courts, because economical courts, they kind of have from commercial, they have kind of have the opinion they will be intervening into the matter of the case. And in order for them not to have this kind of temptation, let the general courts do that. And that is something similar when the economical jurisdiction court was invited and he's saying that he knows how to do arbitration because he changed arbitration, as Ms. Oksana Karol said. He decided to become the judge instead of arbitration lawyer. So let's see how we'll manage it in 1 hour and 15 minutes. Dear colleagues, hopefully I can call you in this way. The session will be working the following way. We will have the guests. They will have around 5 to 8 minutes with the introduction. They will show what do they consider to be interesting and to be important to tell you. And we are not going to interrupt them with the questions. Please collect your questions and please get ready to ask your questions later or pass it to the organizers who will allow me to ask the interesting and relevant question. Important, the interesting and relevant, which are the grounds for the further scientific works, but the ones which are practical, I think that we will be able to ask them today. And after our speakers will have the opening remarks, we will start the discussion due to the fact that we are in Coliseum Hall. So both me and you will be able to ask the questions. So here we have 2 judges. The judge of the Cassational Civil Court, who is, I will introduce you separately. So jurisdiction which has to respect the arbitrational decisions and has to, in some very rare cases, to cancel them. Economical jurisdiction, which has to respect arbitrational agreement. And then we have 2 arbiters with scientific and legal background. So the full set in order to discuss in what is the current situation of the arbitrational practice and the courts on the intervention and respect to the arbitration decisions. What can we expect from this practice, and what do the arbiters expect from the what do they expect from the courts, and what kind of perspectives for the development do we have? Of course, with consideration of the fact that arbitration states that they are ready to expand their jurisdiction and to compete, so to say, not only with in only commercial, so to say, disputes. So that is the organization we have today. Organizational administrative part is over. So I invite Olena Bilanevich for the opening work, the professor of the Donetsk National University after Vasil Stus. And what is important, she's probably the champion on giving them decisions and in the big chamber. So that is who is Miss Olena, and that is the level of her decisions, conclusions, especially when it comes to the cooperative, commercial, and intellectual property rights. Yes, if I mention all the context, right here, you can just start making yourself even more comfortable, because I can be talking a lot about Miss Elena. So I think that with this, Miss Elena, I think that you know Elena as the member of the International Commission on the Arbitration, and Miss Elena will tell us about tell us more about arbitration and what kind of interaction do we have between the court and arbitration, and what can we expect from this cooperation. Thank you. Thank you, Mr. Konstantin. Thank you for the introduction. And let me add that not only courtsman, but also the veteran, because I participate the consultative councils in the High Economical Court and then in the Supreme Court since 1999, and therefore I have owned my scientific experience on the topics we are going to discuss today. And from the beginning, I would like, in the framework of the regular time we have, I would like to say a few words about Mr. Pobirchenko, who organized all of us around him on the 14th International Arbitration hearings. And the name of this discussion and my topic, because you remember, probably you remember, the lawyers of older generation that definitely remember that Professor Pobirchenko has made his contribution into the economical procedural law due to the fact that he created the general knowledge about the economic jurisdiction, and his transformation from arbiter through scientist and to the person who was in the basis of the commercial arbitration in the trade chamber of Ukraine, and it shows how this perception can be developing. So why I've mentioned this topic? Because in one of the interviews back in 1994, when the introduction of the law on the commercial arbitration was presented, Mr. Pobirchenko, Professor Pobirchenko gave an interview. He was explaining a lot. He was giving lots of comments on the sense of the arbitration and lots of work left by him. And he said about this law, which is valid, which was not changing much, that it has the spirit of democracy. And I remember those times because Mr. Pobirchenko, Professor Pobirchenko, was a lecturer in my university, and I remember that that was dominant in 1990s in order to characterize the economic life of the society, because democratic spirit, which he mentioned, and the broad rights which the commercial subjects received, they were due to destruction of the monopoly of the state on everything, on ideology, on legislation, on property, on private sector, on independence. It covered each and every part of our spectrum of our social life. And in this law, in preamble, and by the way, till now it is not changed. I think that it's going to stay the same way. These kind of explanation that the arbitration is the method which is useful in international trade and takes in account the provisions which are mentioned in international agreements of Ukraine. So in this way, we have this framework that interaction of the national court with international arbitration is framed by the international agreement, and it has to be in with the spirit of the international legislation. And the legislator gives this kind of tone of communication between the state and non-state, and they are just representing the self-regulation sphere. Broadly speaking, that is a self-organization of the society. And for me, it is so interesting to hear the first session of our hearings today. The key words we've heard today, that is self-organization, and that was respect. When we were discussing my topic for discussion for my speech in this audience, I was insisting that we have to be speaking about respect, not about the support, not about enhancing, even though that are very good words, that are very useful words, they are needed. But I like respect. And Professor Catherine Rogers has mentioned that as a dominant for those relations which have to be developing between the national court and the society. The self-regulation, it is a continuation of our routine communication in the society, and in fact, it happens no matter whether the state is there or not, and it doesn't depend on the legislation. A legislator can try to oppress it or can support it, but the horrible war proves that horizontal connections of us Ukrainians is impossible to destroy. We are strong and we know how to do that properly. And the legal communication is also the form of communication. It also means that there should be some dialogue. And when we're talking about the national courts and the international commercial arbitration, we are talking about this legal communication, which is happening once again between the institutions, and it should not have the form of the monologue. It is always dialogue, but we have to understand that we have dialogue between subjects, the subjects who are not equal, who do not have the same way in our legal reality, because, of course, international commercial arbitration does not have the tools of the and cannot make anything mandatory as the court can. And therefore, the idea of respect is based on the general idea of the democracy. That is what I've started with. And that is the respectful attitude towards everyone. That is the respect to the person who doesn't look like you. That is respect to the opinion which is justified by another person who is different from you. And from the perspective of this legal communication, here it matters what kind of form do we have here, and it happens from the Supreme Court, of course, as the statements, legal conclusions, and by the Supreme Court, and of course, the grounds for it should be the idea that the state perceived normally and supports this refusal to get the services from the state. So the state wants when it comes to the disputes, and their values is the respect to independence of the parties. And therefore, of course, and once again, it was mentioned, and that is something that I like a lot, that the relation between arbitration and the national court should not be in the framework of the jurisdictional competition or anything like that. And we do not need to have the artificial obstacles in order to get the access to international arbitrational court. First of all, it is regarding the practice of the recognition, the invalid decisions, and the implementation of the practice of the court, implementation of their implementation. And of course, I think that this experience of the development of the arbitration and the first dispute, external commercial dispute in the Trade Chamber of Ukraine, was considered back in 1993. In 1993, we had 28 cases, and knowing the current statistics, we know how much we progressed and how positive this dynamics is. But anyways, considering these three components, legislation, national court, and ICAC as the subject of the system, we can definitely say that the relations between them have never been trivial, they were not boring, they were always very interesting, and they remain the ones which keep us toned, and arbitration and scientists are very toned. And of course, we can be saying that as a result of the reform 2023, the positions of the arbitration were enhanced, and this pro-arbitrational approach and the respect from the national court. And here I would like, well, maybe I can illustrate it with my personal experience as the member of the scientific consultative group in the national court, considering the cases which we had during the last 5 years. Maybe it is not very much representative for the rest of the members, and it does not represent all the issues which we have in the court. But nevertheless, considering the conditions under which the Supreme Court is contacting ICAC with a request to provide them with answers, I think that these questions are still in place, even despite their practice, even despite the good practices. Probably that is a reflection of the internal discussions in the Supreme Court. I can say nothing about it, only the Supreme Court can say something, but that's where the questions related to, first of all. That is the recognition of the and implementation of the decisions and delays, and also the nature of the arbitrational agreement and the possibility to recognize it invalid in academical court. And there are two legal positions we had, and in both cases I wrote the conclusions, and one was didn't work, and then we had Olena Kibenko, and I hope we have this position, and that is also position on the side which did not sign it when we are talking about the debt, and that is about the implementation of the courts of the decisions of the other arbitrations, and that is. And I would like to say that among those cases I was talking right now about, we had 6 questions here. Only one resolution was controversial, and as for the rest, the courts, in my opinion, considering the conclusions we had, they were making absolutely correct and pro-arbitral decisions with, and they were justifying their position. But, and here I have to, so everything cannot be just perfect in this area, because we have controversial practice of the court, and we have to be honest about it. And me as scientist, I can do that. And it is about the implementation of the assessing categories. So that is the public order when implementing the international decisions. So when there is a threat to public order and when the court doesn't see it, and how it is how about the attempts to make it equal to the eligibility, and how ICSC has violated the court process, or how they did it incorrectly when it was speaking of the procedural justice, and that it doesn't meet the main grounds of the legislation. So there is a tendency that trend to fill in. I cannot even say that it's a kind of niche which cannot be empty. That is a sphere where, from the Supreme Court, nobody expects to dive deeper in the procedural peculiarities, in studying the evidences, whether the terms were fine, whether the procedures were fine. So all of these things are not the part of the assessment of the Supreme Court, and that is something that we have. So we can be saying that at least that is not the trend, but there are some separate attempts when the state court is trying to make arbitration, to have some kind of procedures which are not typical for arbitration and which are not recognized by the international community, and which are not fundamental principles for arbitration and arbitrational procedure. And finally, just a few more words. I think that considering the fact that legislator is expanding and planning to expand the number of the disputes which can be resolved by ICIC, I think that there is a kind of threat, because due to a lack of high quality legislation, let legislator forgive us, due to its lack of formalization and lack of definitions, and they have to be interpreted, first of all, by the national court. Arbitration can also be in kind of turbulence when arbitration acted in the framework of the same framework as the national court. It has to hear and has to react and has to build their own positions, or not to build it, or to agree with the court regarding the categories which are outside of the legal definition, but which are quite vulnerable. And in this case, I'm talking about, according to the practice of the Cassational Economical Court, that is about the definitions on what is civil legal aspects of the disputes which occur when during termination of the contract on the public procurement, and that is the sector we were talking about, that is a bankruptcy. Because we have to understand, we have to be clear about it, that bankruptcy is one of the most stigmatized ones in the court practices. We have bankruptcies which last 20 years and even more, and that are very difficult processes. And after the public creditor appeared, who have to be acting in some certain way. And in this creditor, there are the different interests, and the tools of the code on the bankruptcy, on the consideration of legibility of the bankruptor, and they are misused. And that are the additional challenges, which, if these kind of cases will be transferred to the ICSC, that are the challenges also for arbitration. But I think that anyways, this kind of legal communication, it has to exist. It has to be the way, and also through the hearings, through the communication, through articles, through letters, through conferences. In any ways, it is a way for these two different worlds to find absolutely similar approaches. Because in fact, all of us, we have to deal with the fact that the interest and the business's interest has to be exist. I even didn't dare to interrupt you when you were criticizing the practice, because you actually, you provoked the discussion, and we remembered your words about monopoly, and not like the others. Very difficult questions for bankruptcy. Leave it for Olena Kibanko. And with this, I'm inviting for the word the Court of the Cassational Economical Court, which used to be in the first big chamber, the first generation of titans who gave us the position in the fervators in avant-garde of which we are moving forward. And in my opinion, that is a very positive experience, because that is a stability of the grounds which is remaining until now, and we will mention that later. And we will mention what they do that time, and how does it have the impact on the arbitration which wants to expand. Inside Dmytro Gudima is the PhD in legal sphere, and his scientific interest in anthropological rights of the human, and maybe artificial intelligence will use his science on how to substitute the lawyers, and he's probably the only one who will remain there to communicate with artificial intelligence. So we invite Mr. Dmytro, who will tell us about. Well, I've seen his presentation, and that is going to be the presentation of his book which he prepared yesterday or today, with all his new practice of the Cassational Court, the practice till 2023, generalized by the Supreme Court and published as a digest. And I think that arbitration practice knows about it, and the Cassational Court, well, we remain it for you to tell us, and who will have also 5 to 7 minutes, please.
Thank you, Konstantin Mikolaevich. This introduction was very peculiar. Anthropology is not actually part of my interest. Thank you, Konstantin Balash, for his creative thinking and how he can introduce the constructs for specific relationships, and that's what we're going to tell to talk about. As Elena said, that we have to talk both about positive and negative, and I will try to illustrate this contrast between the positive and negative using specific examples. Some of the examples will be on screen, and I will tell you about something orally, and we can have some additional issues to discuss. So I'm going to use it. Where are you sure this gadget works? Dear colleagues, okay. Oh, start to work. Oh, great. It has started to work. You just directed it at the projector. So the first issue, I hope that the screen will unfreeze, that the jurisdiction of ICAC on the agreements provisions. So the case that the Supreme Court had under consideration in January this year. So the issue was two parties signed an agreement on purchase, and there was the contractor and then the vendor, and the purchase was done over internet, and an invoice was sent via the internet. So everybody agreed so that the law which is going to be used, material law, is the Netherlands law, and the issue is going to be, the case is to be appealed in Utrecht, but the vendor suggests so that an agreement should be signed in hard copy, in written form, and the other party agrees, but makes a clause that if there are any provisions in this agreement which are not in correspondence with those contracts provisions which were agreed in the internet, then the primary contract is supposed to be used. The point is that the written contract included the clause on the use of International Court of Arbitration of Ukraine. And there was a conflict about whether there was the jurisdiction of International Court of Arbitration of Ukraine. So what the position of the Supreme Court of Ukraine was, and what could it have been under other conditions? So the key question, whether the arbitration agreement was signed, whether it can be considered operational. The Supreme Court paid an attention to the fact, to the clause of the contract, that the written provisions have the superiority over those which are agreed over internet, and that's the only prerequisite why arbitration agreements had the superiority over the primary contract. And there is an interesting question: what it could have been if there had been none, and there had been no such clause, whether this arbitration agreement could have been considered valid if there is a if both versions are not if they are reconcilable. In this case, actually, the International Court of Arbitration of Ukraine had the jurisdiction. The second group of cases, they were not about jurisdiction, but about the creditors under sanctions. And this issue is very important. There is a practice of the Supreme Court on the cases when we have the creditors under sanctions and they received the arbitral awards from the International Court of Arbitration, and the issue was whether it is in principle possible to use the arbitral awards, arbitral judgments, to use the assets under sanctions. And the Supreme Court said no. And well, it seemed okay, but the next question was, who is in the position to interfere and to challenge the judgment of the first instance court? And the Supreme Court's judgment was that the prosecutor can challenge or appeal such judgment. And of course, there were some details about the timeliness of the documents submitted or not, but the specific feature of these cases is that there is a public element and a prosecutor is entitled to appeal or challenge such case. The third type of cases is about the design of the procedure, how the assets can be relocated. So the issue was that there was an arbitral award of the International Arbitration Court, but then the sanctions were introduced, and then we have a new creditor who is cleared of sanctions. This new creditor submits a statement claim to rectify the International Arbitration Court's decision, but Supreme Court refused. And despite the fact that the arbitral award had been done before the sanctions were introduced, still there was no space and there was no possibility to use this arbitral award. And so you cannot substitute the defendant which was under sanctions with other defendant which was not under sanctions. And so the Supreme Court banned such practices, but such practice can repeat. The third issue, and Alena already mentioned that, about the postponement of implementation of the ICAC's decisions or arbitral awards and the respective court's judgments. And it is not possible to do it at the national court, and the Supreme Court made a judgment that both the first instance court or Court of Appeal cannot challenge, cannot postpone the implementation of the International Court of Arbitration. My personal position is contrary, and there were different judgments at the level of the first instance courts, like, for instance, Kiev Court of Appellation provided access to the decision of the arbitration court, but in this case, it can be done only within a year after the arbitral award was done. But in this very case, the request was done after 2-3 years after arbitral award was done, and the Supreme Court declined such a request. So the postponement cannot be done after 2-3 years. About the cancellation of ICAC's awards or decisions, I will give you an example. It is not typical. So that was the case considered in my chamber. The specific features of this case was that one of the parties considered a violation that the International Court of Arbitration made a decision upon the falsified documents. And but the information, one of documents, was not fully proved, and those who had provided this information, they recognized that the information was not correct, but the document was not falsified. So in this case, when there was it was just about the speeding up the delivery of the goods, and they ordered the expertise on the specific type of grain, and so they just wanted to speed up the delivery of this grain, and so they received this expert's opinion, and there was no proper check, but the border control at the border of the Poland showed that the chemical substances surpassed the allowed level. So it was about the lack of integrity of the purchasing party, who was supposed to check the quality. On the other hand, there were specific provisions of the contract. And under this contract, that was the vendor who was supposed to check the quality. So the first instance court made a decision that the primary judgment of the ICAC's decision about falsified character document was not correct. It was about the integrity in the implementation of the contract's provisions by both parties, and therefore there was no foundation to cancel the ICAC's decision. The last one, the most controversial one, and these practices happen all the time. That about the providing the second copy of the enforcement letters if these letters are already used. And we were already discussing these practices, and we were discussing the point that the criminal procedural code's mechanism use of these duplicated copies is not applicable, and there were ideas discussed in this area, and we discussed that it is not possible to bypass the provisions of the law on the using these second copies of the enforcement letter. So the current provisions of the criminal procedural code include the provisions how to restore the property items using these enforcement letters, but the Supreme Court made a decision that if a plaintiff uses the double or second copy, that's actually the practice how to bypass the rules of the Criminal Procedural Code. So, the Supreme Court made a very clear statement here that you cannot consider the first copies to be lost in this way and just legally issue these second copies. And this year, the Supreme Court made a specific judgment with a different approach. And this different approach is about when the enforcement letter is confiscated, then the civil law is applicable in order to use this second copy. So this story is about the two judgments in the sphere of appeal. These are not cassations, but these are practices which are not compatible fully with each other. And I think there is a ground here for discussion how to deal in these cases. Thank you for your attention. Thank you, Dmitra. Please take a seat, dear audience. And within 15 minutes, you received the most important cases from the Court of Cassation. And we will get back to your topic on the Supreme Court's judgments on the creating climate for arbitration, pro-arbitration climate, so to say. So we have to identify the roles between the arbitration court and the regular courts. And I would like to give the floor to Alena Kibenka, and she is from the first generation of titans from the chamber. And she is one of the authors of the judgment on the mandatory character of the arbitrations awards, and that you cannot challenge such arbitral awards. So Alena is the best authority to judge about the respect towards the judgments of the arbitration courts. And so now she can tell more about the court practices in the sphere of conciliation. So we can think about the dividing the spheres of responsibilities of the arbitration and regular court. So it's not about the competition. So if we can discuss the cases when this competition is possible, we can hear Alena. Alena, so thank you for your introduction. Please upload my presentation to the screen. I would like to say that in contrast to the civil law cases, the business law or economic law courts, we do not compete, I would say, with arbitration courts, but our competition is not that regulated. And it started from the moment when the statement of claim comes, a motion comes, that there is already an arbitral award, done, and then court has a dilemma, a very difficult dilemma, or to limit the access to court, or to consider the case in place of arbitration courts. So whether it to give it back to arbitration. So the complexity of this dilemma is that a judge has to make a decision. And so we consider this complexity. If you read the procedural codes, it seems to be simple. But if you have actual case and you have the arbitral clause, so then how going to deal with this case? How are you going to deal with such case? Are you going to hear any witnesses? Are you going to accept any evidence? So we had a lot of discussion on cultural backgrounds, on the rules, on education. I'd like to compare. We discussed this issue at two joint chambers. One of the chambers said that there is no dilemma. Here is the regular case, and it can be appealed. And we didn't see any problem here. And I thought about this for a long time and understood that the international private law has not been properly studied. It is studied in universities, but in very limited way. There is no long history behind it. And those judges who studied the international private law, international arbitration, it is very difficult to explain to them that the competences and the modern arbitration professionals, they are much more knowledgeable about such things. And in 2020, we started to consider such cases, and we got some first judgments on these issues. But in 5 years after the first start, we didn't have controversies because we had new judges now, and these new judges understood what arbitration was. So it was the change of the mindset. This transformation in education had a very big impact over judges' judgments. And they now understand much better what the arbitrations are, and they understood what a dilemma, what this dilemma is. And so the judge can already consider these dilemmas before looking into the case on the merits. So it was the first thing to be decided, take into account the time limits, the amount of evidence. I will get back. And what helped us when we had this first bunch of the joint chamber, we tried to describe the sequence of steps for a judge to be taken in such cases. And there are more and more cases, and there are more and more judgments of the judges which are pro-arbitration. Because earlier, they were sort of like afraid of signing to access, signing to limit the access to courts. But there were several ECHR judgments stating that international arbitration courts judgments are equal with the regular court's judgments. And that's about the respect to the arbitral awards and arbitration court's judgments. And I'm happy that this practice has become more popular, and Ukraine is becoming a jurisdiction which is more pro-arbitration. And we already discussed this issue so that to engage international partners to have the cases to be issued in the arbitration, and getting more into practical issues. So what is the norm to regulate the arbitrability of the dispute? So there is Article 72 of the Economic Procedural Code on the cases which cannot be considered by arbitration courts, and there is an article of the law. So if we take a proper approach, the Article 77 of the law does not is not applicable for assessing arbitrability. That's about the recognizing it's about the how different countries should be assessed against the background of the dispute. And I read one of the judgments on this issue, but I would like to draw your attention to the fact that that's about the knowledge, how these provisions of the law cannot be applicable. And we already made a statement on the Article 77. They look similar. And I think that the Supreme Court made a correct decisions, and that I wanted to draw your attention to this sphere and why it is important to discuss this pro-arbitration.
Можна ухвалити рішення про те, що спір є арбітрабельним, а можна ухвалити
So we can
рішення,
make the decision that it is arbitratable or not arbitratable. And this kind of situation, which the Supreme Court faced in the last few years, is a division between cooperative disputes, which unfortunately are not so arbitratable, except for a few cases, and also the statute capital, where there is no limitation. And with this, I would like to introduce you a few cases, where the first case was back in 2023, but here was the question of the recognition as non-valid, where we referred, where the parties referred to the arbitral cautious, and therefore these case should not be considered by the economical court. And the research case that was also in my report, that is a decree, the new one as of the September 2025, and here it was more interesting because a dispute was about the parts of the statute capital, but in fact all their demands, all their requirements were coming out of the procurement of the parts, and therefore, considering the provisions which were formed in 2023, but I supported the case that it is the subject to the arbitration and it can be considered. So the cautious on the passing it to the international arbitration court is possible. And very, very interesting approach. And today we've heard a lot about bankruptcy, and I'm very glad that both the members of the parliament and the practitioners, they are paying attention to this matter. Why? Because at the moment, in the legislation, the comparison of the arbitration caution and arbitration process and the bankruptcy, they are not regulated by the current Ukrainian legislation. And by accident, in June 2004, I participated the working group. We have CFOC organization, that is a forum of the commercial or economical courts, which unites the courts of the economical courts all around the world. And the objective of this organization is to support the economical procedures in order to keep the standards, and quite often the judges in so-called closed meeting, they are discussing the practical matters. And we should have had the member of the bankruptcy chamber, but due to the important reasons, he did not participate, and I was the one who took his place. And one of the questions we were discussing, that is a comparison of the arbitrational agreement and the sorry, technical issues.
Так, і розглядається спір.
And then consideration of the the consideration of the case. So that is what has to be prevailed: arbitration or credit ring approach. And in only in some jurisdictions there are the laws which regulate it, but typically the bankruptcy laws they mean that if there is the matter dispute, then this dispute is out of the bankruptcy sphere, and the concept of the concentrations of the factors does not work in this case. The creditor ring approach doesn't work, but just a few jurisdictions have this kind of regulation. And when we had the meeting with judges, in fact, they said that they are resolving these issues in different ways, and each case is individual, and each court, in each case, he makes a decision which he or she considers to be justified in this specific case. And after this, so when I was looking for the practice, I was surprised, and today I told about this decision. It was made in 2023, and I'm very proud of this decision. When I found it, I was just fascinated with my colleagues who made a very good justification, and in fact, it was very good decision, and on this arbitrational approach which was implemented. So if there is the matter dispute, the colleagues were telling about it in the first session, and therefore I'm not going to tell more. Very interesting case. And here I have identified decree number 2. I mentioned it as a pro-crediting approach, but I cannot call it even a pro-crediting. Why? Because even in the first decree back in 2023, Barbanasco was the reporter who is now in the big chamber. At that moment, there was a division, very, very clear one, as we were discussing on CFOC working group it. So Ukraine, even without all of this information, somehow intuitively made the good decision. If there is the dispute on the matter regarding the debtor and there is the arbitration decision, in this case, a judge has to make the decision that in this case, this dispute cannot be considered by the economical court, even if it is about the debtor. If you are talking about the procedural cases, issues, and here it is interesting because Hong Kong investor has initiated bankruptcy due not fulfillment of the crediting case, and the London court, as far as I remember, should have considered this case, and then it went to the Supreme Court, and a Ukrainian subject was trying to cancel the launch of the proceeding. Yes, I'm finishing because. But nevertheless, the Supreme Court remained the decision of the judges because it was about the procedures. And in this case, they have applied the pro-crediting approach. Thank you very much for the attention. Thank you. I hope that Mr. Dmytro and Ms. Olena will return in 1 year. The second presidency will be over, and they will recover their skill to be brief and to manage to say everything in 5 minutes. Dear colleagues, let's invite to the word the person with legal, with lawyers approach. We've heard lots of compliments today, and I think that Mr. Roman, who will correct all of it, maybe he will point out maybe some kind of gaps which we can improve, or maybe some things are something we should not be doing, or maybe there is some kind of abuse from the community of the representatives of the lawyers. Why we are talking only about the judges? So the portfolio of Mr. Roman, the number of the awards and the number of the first places due to the practice of the decision of the disputes and arbitrational practice is impressive. I did not dare to press the button see all the awards because, even what I've seen was already enough just to be amused, because Mr. Roman is the only lawyer in the practice of the arbitration of the disputes on the national level, and he's in the chamber rates and legal 500. So for me, as the person who came from private practice, means a lot for me. And the fact that he is arbiter who has in his portfolio the cases in energy, natural resources, and real estate property will allow me to ask the questions, and to Ms. Olena Volinevich, who has specialization on ICSC. It is these directions are also stated there. The questions about the development of the arbitration and the related challenges. But with this, we're inviting Mr. Romand with his vision, and I hope he embodies the thoughts which are similar to all the practitioners of the arbitration and dispute resolution. Greetings. Thank you, Mr. Konstantin. First of all, I would like to thank all the team of ICIC on my behalf, on the behalf of the people who faced these attacks of the Russian Federation. It's impressive that you continue this work and that you gathered us today. Well, what I want to start with, there is a saying, Supreme Court of the US, there are 9 people who are correcting the mistakes of the other people, and they are making their own mistakes eternal. And I would like to emphasize eternal. And with this, I would like to speak of our Supreme Court. Let it not be personal, but let's be honest. Big chamber of the Supreme Court, which was established for these purposes, and the Supreme Court, all this function of the unity of the court practice is not well implemented, because endless changes of the approach of big chamber and the other chambers, it is not acceptable for the legal state, especially in these amounts. And maybe the judges are not have changed the practice, but for the society, for the community, for business, this legal framework is more important than some separate dispute, which for some reasons we have to resolve this dispute in other way today. So if I will have time, I will speak about this as well, but many of the things which I wanted to say, they were said today. The first problem we have, and in fact, it is an eternal problem, the problem of the implementation of the doctrine of the public order. These legislative activities of the court, which use this definition in different interpretations in different cases, of course, that is a problem. The problem which we had quite long time ago, and if you remember, my legal company participated to this case back in 2004, 2003, 2004. 2 planes Antonov were arrested in Canada and Belgium. Why? The Cyprus company demanded funds from the state fund, and the fund has won the arbitration in Stockholm. In 5 countries, the decision was recognized, and guess where, with reference to the public order, they got refusal. We were the state company party, and it was everything okay. But with the reference to the public order, we have the prepared audience, so I'm not going to refer to the wonderful decisions of the Supreme Court, which correctly describes what is public order. Of course, we do understand that is an exceptional case. But nevertheless, it is not an exceptional case. I do not know how to say it correctly. We probably have enough corruption. But the main thing is here the political importance, relevancy, the public relevancy. What's have against Odessa port company? The decision is against public order because the debt leads to the threat to stop the plant, and mandatory fees which will make impossible or which will make difficult to privatize it, and there is it contradicts to the public order, as the court says. And Mr. Dmytro has mentioned this story, and indeed there is a sanction story, and yes, that is a problem. We are now in the middle of the full-scale war. There is no question. All of us, we hate Russians, Katsabs. We hate them even more today. We hate everyone who support them. But we have to understand that the president and the National Council of the Defense, they can also make mistakes. And they can also include someone in the sanction list, and then it can be changed in the next cases. For example, my understanding, we have legislator, and he has foreseen everything. Everything is clear. He has stated that it is not allowed to withdraw the capital for the benefits of for someone. But the sanctions can be cancelled. So the sanctions can be recognized by the court to be incorrect, and many other things can happen to the sanctions. And therefore, we should not be refusing to recognize these decisions. The Supreme Court has to the arbitration decisions. It has to recognize, and then the legislator has identified this how we proceed. He stated that the money cannot be withdrawn until there are the sanctions imposed against this person. Unfortunately, the Supreme Court practice sometimes is different. So Ostham case, which I've mentioned before, and why decision is against the public order? Because in fact, the one who received the benefit due to the mandatory implementation of the decision is the Gazprombank company, which is facing sanctions. All of us hate Gazprombank, but the decisions which are legal from the perspective of the legislator is to give permission, and then the state executive service is refusing to implement it. And that is a correct way, because let me mention another thing. The sanctions sound as temporary things. And unfortunately, the legislator went even further, and we can see that in the higher anti-corruptional court, the money is withdrawn for the benefits of the state budget, and they are confiscated, and the legislator can decide whatever he or it wants. And therefore, I'm saying, why are we refusing to recognize it if then that is the state which is going to do that? Because the state is the one who is going to implement this decision. Why are we refusing? And then Mr. Dmytro mentioned this case. The only thing there is a technical decision. It was not ICIC decision. It was ad hoc decision, which was not recognized. And the first question we have: who has made a complaint? That was the prosecutor's office, which could not decide who should be the one who is applying these kind of cases. And they mentioned the Ministry of Justice and the State Security Service of Ukraine. And it happened 1 year after the State Appeal Court gave the permission to implement it. So the Supreme Court doesn't see the problem and implements it, and it cancels the the permit issued by the other court, and even more, the fact that there was an issue not of additional measures, but the fact is that the debt was given to another person from the person who imposed sanctions. But to close this sanction story, I can say that in my opinion, the question is quite similar. We have political relevancy, and our national members of the parliament have to do that. The court has to use the laws and not what Mr. Dmytro has mentioned in this decree of the Supreme Court. There is the thing which the sentence, the verdict which says can lead to overcoming the sanctions. So the criminal court is just considering to add the definition of what is overcoming the sanctions. And what we've started with? We started with the fact that we have the special, we have lots of these kind of cases, and Ms. Olena and Mr. Dmytro, all of them, they stated that we have to move from these controversial, as they call it, decisions, and we have the case. A Russian company, Aviafet Service, against our company entity Artem. Two cases about the recognition of the decision of ICSC. So in one of them, it is not allowed because it is against the public order. Great justification. It is the industrial defense sector. There is sanctions and there is a threat to the national security. Everything is described really well. Then there is another in the similar case. So the same appealer, and there is another date. The position is other, and the Russian Federation, which is recognized as the aggressor state, cannot serve the reason for not implementation of the decision. And under some certain circumstances, there might be the conditions in order to implement the executive measures. So the second decision is correct, but nevertheless, the first decision on the 9th of January, and then the second decision on the 13th of February. So how can we build the legal state and be speaking about some legal clarity if the cassationnal civil court, the people who are sitting next to each other in the nearby each other, they make two different decisions? How can we suggest our clients how we can consultate what to do? But in arbitration, in fact, the situation is more or less okay, and we have pro-arbitrational climate. And I can tell you the real case of my client. We have the position of big chamber that the similar decision, the similar cases have to be considered by the administrative court, and therefore we go to administrative court. We win in the first instance, and then the position of the big chamber changes. I do not know what was happening there, what has happened, and the appeal sanctions tells us that go to the economical court, and that the period is violated, and they are asking me, you're lawyers, you don't know where to appeal? Okay, I'm finalizing. Look, we see what is happening in the Russian Federation. And if they have political relevancy, they make the law, and the Constitutional Court might not be fulfilling the requirements of ICHR, and we are fighting not to be the way they are. And let's be asking our wonderful judges, first of all, the Supreme Court judges, and then the big chamber, let's be making the decisions based on the legislation, not based on the political relevancy, even when this political relevancy has good intentions. Thank you very much. Thank you, Mr. Roman. Well, I asked it myself. I was asking about critics, and
I got what I was asking for. That is how it should be. But the thing is that whether the practice of the Supreme Court in sanctioned cases it has an impact on the general image of Ukraine as pro-arbitrational state and the arbitrational climate, let's omit it for today. And I think that Mr. Dmytro and Mr. Roman, they do not need to discuss it that much because each of them, they have different experience and they have the chance to go through these cases and to have their own opinion on the cases. And I think that with this, Coliseum has already started. Mr. Roman has already gave us some certain tone. And let's return to the general topic of the panel. And if we have if we are able to open the discussion and to listen to a few questions, we would be glad to do that. Dear colleagues, in order for us to understand the system, where we are now, the brief question, the brief answer, and then we will move to the pro-arbitrational climate and the role of the judges in the establishment of such climate. The commercial dispute, is it a service, Ms. Olena? The floor is yours, if you don't mind. Yes, that is a service, but that is my my position. Okay, Mr. Roman, no, it is not a service. Yes, it is a service, as well as jurisprudence. So, you know, the children in the university are taught what is jurisprudence. That is business. No issues. It is not science. It is not art, even though we can be discussing it a lot. That is a business, the provision of the services. And ICIC is about it, about services, not service, not service. Okay. So we have this unity because we have to see the unity of practice. And we have two to two, whether it is a service or not. No, I'm not going to answer that. The role of moderator is to be out of the discussion, and all these questions are for you, dear friends. So the first session was very optimistic, and we even have legislative initiatives on the expansion of the restriction of the arbitration and the provision of the opportunity to resolve the investment disputes. And we cannot have the same opinion about the fact whether it is service or not, and the monopoly of the state will be affected, or maybe we are talking about not about monopoly for provision of such services. Well, difficult question, and it is difficult both for the judges who were making who had their practice in the big chambers on the efficient ways of the protection. And I guess all of you know this growl, and that is a milestone, and also for our honorable practitioners, scientists and arbiters who specialize in real estate disputes, energy, construction, and everything else, where not only we're talking not only about withdrawing money. So I'm referring to Mr. Sullivan. 9 out of 10 ICIC cases are about withdrawing reimbursement. This monopoly went through very difficult times. And okay. So, dear speakers, I would like to address it to you. If indeed we will have the expansion, the implementation of the arbitration, the cases will be more difficult, and they will be not about withdrawing money, but about forcing someone to do something, to transfer the property, maybe even to recognize some kind of right, or to recognize no right. So the problem, which is probably the biggest one at the moment, and the efficient protection, that it has to be efficient, it has to affect arbitration and how arbitration and arbiters have to understand this practice, how they have to know, how they have to consider as a part of the national order, or maybe arbitration has to have an impact on the courts. It already has an impact. Since 2018, you can see the decrease, the resolutions of the Supreme Court, and the court will become not the defender of the rights, not the one who is defending the rights. So why I was asking about it, whether it is a service or not, or maybe that is the right for defense, but the arbiter who will be saying who is right, whether it will be on the level of the execution of the arbitrational decision, or maybe that will be the part of the services of the execution services, who will be suffering because they got the decision which is if not feasible to implement. Whose problem is it going to be? The judges, who will probably be blaming arbiters that they are changing something in the arbitrational decision that in order to make it feasible, or the arbiters who have to reinterpret the practice of the Supreme Court, the requests which are not efficient, or maybe we should be providing the services that this parties request for, and then it is their problem because they are not able to get the proper implementation. So what is your opinion about it? Thank you. Mr. Konstantin, I think that the problem of efficient defense, considering the fact how we have it in Supreme Court, that is the bad dream for the arbitration. When the Supreme Court states that yes, the way of defense is meeting the requirements of the law, yes, it doesn't contradict anything, but in the court opinion, and especially when the court states that they are canceling the decisions which are made regarding this case, and now the complaint he has to think how to move forward. And I think that arbitration has at the moment very big benefit when it comes to this matter, because considering the practice I was working with and which I know about from my colleagues, the grounds of the international commercial arbitration, they have economical and legal approach on the level of business. And if you have the business goods and money, that is incorrect from the very beginning, because that is not the way how business works. It cannot be in the same hands, and therefore it seems to me that the discussion on the efficiency of the defense is in the way it is, it has to finalize by the Supreme Court, or it has to end in the way that me as a court, by providing the assistance, and I identified that it was violated, my rights were violated, but I can see that it has to be defended in the other way, and I'm the one who is going to implement the other way of defense. That is the violation without positivity. The complainer did not ask for that, but you completed the defense function. But let's not about the court, but let's talk about arbiters who are requested to make it mandatory to pay something or to pass something. Should they also use the efficient way of the protection? And where English professor will know what is the efficient process. Okay, it's not it's about whether arbiters have to be prepared for the realities of Ukraine and whether there is an advantage of Ukrainian arbiters. Well, I'm for simplicity. Together with Grigory Skryabata, I'm for simplicity, because if there is a debt, there is money, whatever you call it, withdrawal or reimbursement or anything else, but if there should be money paid for some certain actions or services, or some actions have to be conducted, then we have to consider the sense of the relations which we have between the parties, and whether the party was able to prove that the rights were violated. If the rights were violated, then it has to be protected, and the party can be wrong. And sometimes, you know how sometimes the agreements are written badly, how the explanations are made, and therefore, Mr. Dmitro?
So I have still a microphone. Dear Konstantin, you asked the question. I don't think that we can reach the shared understanding in terms of the joint answer. Alena expressed her opinion. There could be counter-argument to this. So arbitration have to take care about the enforcement of its decisions the same way how a regular court does. And if we speak about the demand to confiscate funds can be mandatorily, or we could demand the creditor to return the funds, and the creditor may promise that, well, I will return them once, and there will be no timeline. And of course, there will be different types of how to proceed with that in terms of like fines or anything else, and without strict responsibility. But the question that Konstantin Nikolaevich asked hardly has a absolutely ultimate answer now, but the authority of the court decisions must be equal, like those of arbitration courts, and vice versa. We are all interested in the proper enforcement of both decisions. Let's park this issue and then to see the perspectives. And when Alena said that a court may interpret the peculiarities of the case depending on the state claim statement, and that happened also in the Supreme Court. But the statement of claim can be different, and we can clearly see that there will be no dispute, because dispute resolution, it's also a part of the process, so that both the parties could find a solution, irrespective of whether they are doing this in the regular system of course or in the arbitration course. So in many cases, the claims could have no perspectives to be attended, and a defendant may not have the specific mechanisms to protect itself, and there may be risks. I wouldn't say that there is just one mechanism to resolve such complicated issues. I didn't insist upon saying that it is the only way how to deal with this. I just wanted to say that a court is not entitled to say that the whole case must be suspended. Roman, you as a arbiter, what is your opinion? If there is a claim on stating illegal of the claim on the construction site, for instance. And my opinion is the following, and that's very related to the issue about whether it is service or not. I will go from afar. So you cannot go to a UK court without a lawyer, without attorney. It's just not possible. And in any way, you must have a lawyer. And we need to have the same mechanism. And so if a defense lawyer design a claim on behalf of a client, then it is not the prerogative of a court who states how you are going to phrase this claim. It is my role of a defense lawyer over a citizen or my client who I represent. I would like you to defend, to protect my right in this way. That's my claim. And what Alena says, that if they dictate the way how to protect my right, and then I will have to spend like 3 years how to do that. That's not the proper way how to do the things. So now we are discussing most of the arbitral awards about the getting funds. So the question is, if they have different cases, various cases about confiscation of assets or something like this, and Roman's position is that if a client wants this claim to be decided by the arbiter, but if you approach the enforcement system with the decision of the arbiter and say that the state has to implement this decision, so it's the issue of a client. So most of the strange claims are dependent on the fees. So arbitration fees can be higher because our French court fees are much lower. So probably they formulate these claims in such a way so that to avoid a higher fee. So maybe the state must reformulate its position to the court fees. In UK, 3 million cases are decided without any lawyers, like using digital software. And you can just use the app and submit a claim about, for instance, rent pay or something. So defense lawyers are not key figures. So most of the countries are now on the way so that to avoid the multiplication of cases. So there can be a lot of solutions. We don't have a lot of practices of alternative legal demands. There is discussion about that. So we have to have complex approach. There are no simple solutions here. We shouldn't have like 5-7 court judgments in order to address business issues. And so it's not so simple. So it's not about the court fees. I think this specific claims That's about creating pre-judicial in order to favor other cases, or if sometimes the goal is to identify new circumstances when specifying these strange claims. So I don't think that the issue is only about the court fees. So we're going to finish now, but let's benefit from. We have the question from the audience. So please. So the enforcement community. And director, I'm private enforcement officer. So what are the limits for courts' control over arbitral awards? So because we have a precedent, and if, for instance, there was a decision of the first instance court, how are the courts involved? And so what about the changes in the procedures of the implementation? What about the confiscation of the assets which are not properly registered? So there are some negative practices in the civil jurisdiction, because courts cannot have their control because it was not the court which had made the judgment. So I will refer this issue, but well, let's see that it is the Ukrainian court in this case is supposed to be responsible, because there must be court's control over the enforcement of the arbitration court's decision. So, how it can be implemented? What do you think?
Дякую. Я думаю, що більше до пана Дмитра питання.
I think it's the question to Dmitro mostly,
Репліка, зверніть увагу,
because
ситуація відома.
there was
суди трошки
command
краще до цього відносяться. І
the
розглядати цю категорію питань в цивільному зараз трохи по-іншому. Моє питання,
court's practices are various. My position is very simple. The International Commercial Court of Arbitration, if they made their decision, then their role is over. Then the enforcement system goes into place. So it's not about the control of the state. If you have this enforcement letter, it's just the standard procedure that you are supposed to stick with. So, and courts must just play their role, and but we are discussing the speaking about the actual getting funds. So what about what sort of control you would like to have from the courts? So there are some. So there are specific provisions from the criminal procedural codes which courts are supposed to do. So it's about the allowing some enforcement agencies to do what can be done in this case. So it's not actually the question. That's about to explore this problem and explore the practices of the courts of cassation, courts of appeal. I can understand this issue, so I'll try to discuss it with my colleagues, and probably the Supreme Court have to to compare the practices from economy courts and civil courts. So what are the problem issues are now in the practices of the Supreme Court? So I can discuss some issues in the Grand Chamber. I can see this about the agreeing the positions of various judges. What could be the problem issues on reconciliation of practices, which practices are not so stable like it is in the arbitration community? Because sometimes there are comments about the incompatibility of judgments within one case. So I think you can properly understand, can differentiate from the traditional way of judgments and some novelties. So what could be problem issues to look into in future? And if we're speaking about arbitration practices, what could be the avenues for improvement, and where we need support from legislators to strengthen arbitration and thrive? So I think this relation between the bankruptcy and arbitration judgments, there is an avenue. We don't have so many judgments here, but I think the judiciary system may have different views upon this pro-creditor approach or pro-arbitration approach. So I think some of these litigation practices could be discussed further, and maybe there could be different views with different judges. So when Konstantin Mykolaevich suggested me to come to this conference, he asked me to present something interesting. And everybody knows that you should present something interesting at the conference. And when I presented some of the issues which I consider to be critical, maybe under the conditions of our times of war, about the creditors and the sanctions, for instance, it's quite a complicated issue. Roman expressed his opinion. I expressed my opinion, how they should be viewed upon, that these practices should be corrected. And the second type of cases, that's about the second copies of enforcement letters I issued when the first copy is supposed to be lost or included into the other cases. So these issues may be really complicated and the practices may be different. Thank you. Dear colleagues, I think so both Supreme Court and International Commercial Court of Arbitration are in the position now that after the Code of Economy Law is cancelled, there were no transitory provisions formulated. What sort of legislature must be used, both in terms of liability, so all the so before the code was cancelled. the Supreme Court has not started to consider these cases after the cancellation of the court, because I think it's the first instance courts which will start to work on them. But due to the fact that there was no ultimate decision of the parliament, I think it is very important to agree the positions, the approaches, what to do, both for the national courts and arbitration courts. What sorts of laws must be used. And if we specifically discuss some long-term contracts, and I think this dialogue must be initiated, because it's about how to legally substantiate some issues, both for our national business and their international counterparts. It's very easy to say, let them change the contracts. But, practically, sometimes it is not possible if you have already a contract and if you're already in the dispute. So it's a big issue, especially from the perspective of creditors. So what about some procedural mechanisms? My position is the same. We have to be grateful to the Ukrainian courts for its pro-arbitration practices. And there was a great figure from the first session, 0 cancellations of the international commercial arbitration court's decisions. And that means that the decisions were professional, and the approach of our courts is pro-arbitration. In terms of identifying the synergy between the Supreme Court's practices, the Parliament's activities, I would like to reiterate us to the issue of exact legal definitions. If our chambers will not be able to unify or somehow to make their practices much more systematic, if they cannot limit themselves their own practices, then maybe we should approach the parliament. If they just mistaken about identifying the jurisdiction for different cases. Dear Lena, I understand the tragedy of each my client for each case. If we want our economy to be developed, if we want to have investors, it is important to understand the future, not the specific cases. If I have a case, if I have a client who comes to me and asks how is client supposed to operate, and I can present 10 judgments which are composed in one way and 10 judgments of the same court and in the other way, then this person will not be incentivized to invest into Ukraine. So we'll see that Alena is very aware of the practices. So let's thank our speakers so that they survive through this discussion. I would like to summarize this discussion and to give floor to the moderator. It's about the arbitration. Is it a service or not? But from the perspective of tax department, it is service because we are going to have VAT. But if we have a perspective from the constitutional law, it's different. So it's quite a complicated issue. So if I got you correctly, if we want to have efficient protection to be done by arbitration, it must be assessed by the court, and if I got you right, that this judgment can be cancelled by the court. I don't understand such practices. If I fully understand with Roman, if it is client position which matters, we have like 30% of the clients who says like, we want these claims to be phrased in this way, but we don't have the right to change the way how the claims are formulated. It's the right of the party to formulate. If he want to stop the case, that's one thing, but it is the prerogative of the client to formulate it. So we can discuss it a lot, and I ask apologies from the judges, and I see this new spirit in the courts system. Maybe I don't fully agree to it, but it is present. So I promised that our respectable moderators will wrap up our event. Dear Elena, it was extremely interesting for me to listen to the second panel. I would like to thank the speakers and the moderator for the perfect moderation. The key conclusion that I can make from today's event, we heard a lot of positive and negative things and controversial things. I think it's extremely important this very case in order to understand the way where we should go. We have to have this discussion to understand our strengths, to understand our weaknesses, to understand how we can discuss them jointly, how we can identify solutions, where we can identify solutions. I think the biggest outcome of this event that we heard a lot of interesting information so that we could proceed with deliberating over it. So it's not that simple. So there are issues that should be thought over, and maybe we should have more meetings and like that. But my key conclusion is that there is a place for arbitration for Ukraine. So we have to recognize the fact that we already have a very good role in arbitration, and we have to be proud of it. And I'm already telling about this at many international venues, and the Eastern Europe doesn't have the high reputation in terms of site or seat for arbitration jurisdiction, and we also have this problem, but these problems are everywhere. And the issues with the judiciary systems are present everywhere, even in the developed judiciaries. So it's not the feature of the consistent problem or systematic problem. So the legislation can change. And these are good signs for development. The key thing here is that we want to proceed in the correct way. So we have to move forward, and we have to promote Ukraine as a seat of arbitration. I think this event contributed to it a lot. Mikhailович, the floor is yours. I'm not happy that we could not discuss all the issues regarding this, about how arbitration can be applied.
щось подібне до нинішнього інвестиційного арбітражу, який, по суті, публічний, і де, ну, по суті, вже звертаються до
And in fact, we are referring to the tools after exhausting some national tools. And when we're referring to the state, and each decision has a magnitude of the impact on the investment climate, which the ordinary decisions of the international commercial arbitration have the tools where we can have the enhancement from the judges and the spheres, where we should not have the intervention. Of course, in 1 hour 20 minutes we're not able to discuss it, but I'm very happy that I provoked the discussions on the methods of the protection, and Mr. McCullough had to point out that what are you talking about? And answering my own question, whether it is a service or not, I have to say that for the judges who make the resolutions on the economical cases, that is kind of medical service. So the patient's comment was what he or she has, and the doctor is given what prescribes what is needed. And therefore, when you are given what is needed, it might be a kind of homeopathy when we expand the service of the implementation of the arbitration, or the pharmacy, where instead of asking the doctor, you say, just give me something, that is self-treatment. And therefore, that is something we have to think about in the future. And indeed, I had no intention to express my opinion, but we have to be ready that either this topic will be the something that arbitration has to be dealing, or something that arbitration or the clients of the arbitration should not expect that the decision in the arbitrational court will be as much executed in the end of the day as the decisions of the courts who take care of the efficiency of their decisions. So with this, I would like to thank you, dear speakers. I think that from Mr. Mikola, all of us, we will get the word of adequacy. Sorry. Mr. Konstantin, continue what you've said to your thesis. We discussed not everything we wanted to discuss, and we have to meet more often with such intellectual circles, and we have to be discussing the problems which create the troubles for us from different perspectives. So the judges, arbiters, scientists, lawyers, and there are very good things to do. 3 years ago, with Mr. Boris Hutko, we were trying to have the joint event with the Supreme Court and arbitration. And we even made an agenda. And he liked the idea, and then they had some other problems, and therefore this agenda was not valid anymore. But I have this kind of experience on this panel, and even though the panel belongs to Ms. Olena Sergeyevna, and we have scientists and judge and lawyer who is using the services and who sees the gaps, and who sees the gaps of the both judging system and arbitration and many other things. And of course, that is very powerful panel, and we have to have these kind of things more often. But once again, I would like to say, I'm confident now that we have chosen a very good topic for this conference. And I would like to say that we are not that well known. We have an image of some third country state with very bad legal system, where it is not worth going to the court. And by the way, the state, the heads of the state management was a part of this process. And I hope that these times are over, and now we have to be talking about the new conditions of the new realities of Ukraine, and that indeed
I know a bit about arbitration, but the thing that is that the judging system works for the benefit of the arbitration, and the judges of the Supreme Court who are here, that is thanks to you, because you did a very big job. And I do not know whether it will continue working the same way, but I know the problems. I know the problems, and Mr. Roman knows, and he also mentioned today. And indeed, they exist, but that is the component of growth. We need to be strong, and we have to continue our strong policy. And Olena said it really correctly. We have to be talking about this on the international forums and wherever else. And we have to say that the French professor, she saw that we are wild and jumping the trees. So speaking of the informational technologies, I think that Ukraine is more outstanding than many other well-developed countries of Europe. It happens so. And also as for arbitration and the court system, well, I was a bit afraid, even though I have not in my age, but considering what has happening at night by the intellectual sort. And why did the people come here? Because they were just interested. They want to hear, and they want to chat. We had COVID, and then we have war, and we lack this kind of a communication, but very strong intellectual moderators and speakers, so that these speakers didn't let anyone leave. So we had someone running here and in and out, but they stayed, and that is also thanks to you, because without these it would have been impossible. And therefore I would like to thank you, and for those who came here, and for those who wanted to say something, and for those who were silent. You did a big thing today. But it is said here that I'm organizer in this paper, and I have, as an organizer, to say to thank those people who organized this event. It's kind of everything is smooth, and even when you had battery discharge in your microphone, the Victor came and replaced it. You see how it's uh, what a high quality service. So for everyone, and the trade chamber of and the chamber of commerce, for everything, they made lots of efforts in order for everything to work. Just look how well everything is organized. And I would like also to thank the ICAC and my deputies, my two deputies, Ms. Inna and Mr. Volodymyr, who were in charge of all of these things, and they take care of me because I'm their elder colleague. And my new counsel, Ms. Irina, she also joined the efforts. Thank you very much. And I'd like to thank our interpreters. By the way, Sergei is one of the interpreters. If he is listening now, he was drafted, and he, in online from Mykolaiivsk Oblast, was interpreting for us, and very good. Thank you very much, Sergei. And let God save you. But we also have one more interesting part of our discussion. That is, I'm sorry. Yes, we also have the company. The company, we are working with them for 5 or 6 years, and this company is in charge of the expansion of the visibility of ICAC, but the Bicentric is also the company which is helping us to do that. It's not always only the thing which arbiters do. And Bicentric does a lot of things in order for these arbitrary hearings to be conducted on the sufficient level. So Bicentric, thank you. Those who were not mentioned, I still highly appreciate your efforts, because I liked, even though I'm very critical regarding everything that is happening around me and about myself, but everything was done really well. And with these, I would like, let's talk and let's discuss the uh, issues we were discussing in more kind of private order. So I invite you for the coffee. Good luck, and I would like to thank those who stayed with us online. Thank you.